at page 48.
But what is the allegation?
The allegations was not included in the show cause notice, my lord. I have no knowledge or idea as to why they were summoning me, my lord. It was just that I was accused of violating the AIFF disciplinary code, but no details of the allegations whatsoever was given in the show cause notice, my lord.
No, there has to be some allegation, isn't it?
Yes, my lord.
The Article 63.2 says that these are the things on the basis of which you can be proceeded against.
Yes, my lord.
But on the facts of the background of your case, what have you done and what is the allegation against you? Apart from this notice at page 48, is there no other material?
My lord, the only material available on record is the...
What about page 49?
Page 49 is the statement submitted by the respondents, my lord.
To whom?
For notification to the public, my lord, to notify the public regarding such unlawful activity, my lord.
So your main allegation is, your main grievances against respondent number 7?
7 and 8, my lord.
7 and 8.
Yes.
Mizoram Football Association. What is this MFA?
Mizoram Football Association.
It's a registered society?
Yes, my lord. Registered society under the Societies Registration Act and also an affiliated member to the MSSC, Mizoram State Sports Council, my lord, which is under the governance of the Mizoram State Government, my lord. And moreover, they have also received annual fund from the MSSC, my lord.
So it all started with page 48, notice?
No, my lord. It all started from the investigation done, my lord. The inquiry report submitted is on page number 38, annexion number 3. The true English translation is at page number 42, annexure 3A.
38?
Yes, my lord. 38 is in vernacular language.
No, it says reference ISOL PS GD so and so. So what happened? There was a FIR filed something?
Yes, my lord.
Complaint filed?
Criminal complaint filed by the respondent number 7, my lord.
Where is the complaint?
I have not the copy. I do not have the copy. This is the only copy I have of the documents, my lord.
Didn't you apply for a copy of that since you are coming before the court? Court also would like to know. So page 42 is a translation.
Yes, my lord.
And
so several club officials along with their players have been interrogated by the respondents number 5, my lord. And
so does the name of the petitioner figure anywhere?
Yes,
in this?
my lord.
Where?
At page number 45.
What does it say?
If I may read, my lord,
yes.
From paragraph number 3, Lelthan Himazema, book 4 number so-and-so, FC Bethlehem. We called this person several times, but since he could not pick up the phone calls, we summoned him through his club manager, Johnny, who is the petitioner herein. Their manager, Johnny, accompanied him when we summoned him. Since he submitted that, since I have missed to catch several balls, I am going to request bonus from the non-Mizo Indian. From his submission and from the submissions made by other clubs whom we have interrogated have also mentioned similar sponsor. Johnny was also interrogated, but since he denied any involvement in the business by the club, the matter cannot be verified. Johnny submitted that Sri Vanal Vena MP Rajya Sabha gave a contract amount of 6 lakhs for the club and the local council to share, and he had used up the same for the management of the club. That was the only verifications that was done by the respondent number 5, my lord. So there was no involvement. He claimed that he has no involvement in the business, and he has also submitted the same during the disciplinary hearing, my lord. Moreover, no material evidences or proof was given to me to prove or disprove any claim, my lord.
No, see, first of all, there has to be a complaint. There has to be an allegation against which you may have to file, you may be asked to submit your response. Then after hearing you, some decision is taken. Correct?
My lord.
Now, here you say that there's some matter was reported to the police.
My lord, if I may have your attention to page number 42, the first paragraph submitted by the investigating officer, my lord. As per the direction given to conduct an inquiry based on the report received from the Honorary Secretary, Mizoram Football Association, with regards to the suspicion of match fixing in the recently held Mizoram Football League, MPL 11, conducted by MFA, my observations and findings as per the inquiry is as under. So from the record, it can be based that there was some report received by the police station from the respondent number 7, my lord.
So what exactly is that report and what is the allegation against you?
The allegation was that I was participating in the match fixing and match manipulation, corruption practices, my lord.
Where is that?
That is not in
It's not available here anywhere.
No,
in
my
your
lord.
Petition. You straight away relying upon the report, that's all. You read out the report, the 11th portion, wherein your name has been shown. You had accompanied one of the player. That much. And since he submitted that, this is by the player. Since I have missed to catch several balls.
Yes, this was by the player, my
This is
lord.
by the player. And the petitioner is the manager.
Yes, is the vice president, my lord,
He's the vice president of?
of the FC Bethlehem.
Okay. So the player has admitted
My lord.
that he has received some amount. I'm going to request bonus for the non-Mizo Indian. Now, where is the vernacular? Let's see if these things are clear.
At page number 41, first paragraph, my lord.
So, police report, then inquiry by this person. And then based on his inquiry, what happened?
Based on the inquiry, disciplinary committee hearing was conducted, my lord, on 31st October 2024.
October.
Yes, my lord.
You were summoned
Yes, my lord.
and you were given a copy of the inquiry report?
No, this we obtained later on only.
Then what happened on that day?
On that day, my lord, I was interrogated by the disciplinary committee, and I submitted that I had no participation in the corrupt practices, my lord, and, which was in the form of match manipulation. Since I was not given any prior information or provided any evidence whatsoever regarding anything, my lord, to disprove or prove my case, I just had to go there and verbally made my submissions. However, my submissions was not taken in by the respondents, my lord. Hence, I was issued the impugn letters, wherein I was banned from taking part in the activity of football or its any other related activities for a period of 3 years. Not only within the state of Mizoram, but also throughout the state of throughout the country, my lord. Yes, my lord. Yes, my lord.
Is violation of article so and so. Where is this disciplinary code? Do you have it? What are the provisions? Is there any provision for appeal?
My lord, yes. However, in the instant case, my lord, that I will bring to your lordship's attention after this submission, my lord.
What is relevant in this thing? What is this? Disciplinary code already.
Page number 38, my lord. Page number 38 of the IIFF Disciplinary Code of 2024. 63.2 is the provisions which has been invoked by the respondent number 8, my lord.
No, just a minute.
My lord.
Promulgated by the AIFF or any other entity authorized by the, in accordance with 32.36 of the Constitution. Where is the AIFF Constitution? This is only a disciplinary code.
Yes, this was the provisions invoked by the respondent number 8 for the sanctions, my lord.
Seven and 8, they are the association,
My lord,
correct?
my lord,
And affiliated to the AIFF.
my lord. They are affiliated to the AIFF.
So there's no separate rules and regulation for MFA?
During the case that was investigated and adjudicated upon, my lord, the respondent number 7 and 8 did not have any code of their own, my lord. Hence, the AIFF, it seems that the AIFF disciplinary code was used by them.
You were referring to some provision?
Yes, 63.2 at page number 38, my lord. This is the provisions invoked by the respondent number 8 for imposing the ban, my lord.
No, prior to imposing this ban, what is the procedure
Excuse me.
for inquiry and all that?
Yes, my lord. To that, I would like to have your lordship's first attention to the, excuse me, page number 42, article number 71. This is the judicial bodies, who are the judicial bodies under the AIFF, as the AIFF Disciplinary Committee, AIFF Player Status Committee, AIFF Appeal Committee, AIFF Club Licensing Appeals Body, AIFF Ethics Committee, and the commissions formed as provided under Article 22.6 of the AIFF Constitution. Now, at page number 45 of the said code,
Yes.
yes, article number 81, the independence, 81.1, the judicial bodies pass their decisions entirely independent. In particular, they shall not receive instructions from any other body. 81.2, the member of another AIFF body may not stay in the meeting room during the judicial body's deliberations unless they have explicitly summoned him to attend. During my disciplinary hearing, both the respondent number 7 and 8 were present in the room and interrogated me, my lord. That I would like to bring to your lordship's attention. And at page number 48 of the code,
Then who is the judicial body? Who interrogated you?
the respondent number 8 was supposed to be in the room themselves, but my lord, the members of the respondent number 7 were also present. The MFA Executive Committee and the MFA Disciplinary Committees.
But you see the language here, it says they may not stay. It doesn't say they should not stay or they should,
Yes, my
they
lord.
will not stay or like that. It says
But
they
their
may not
decision
stay.
has to be independent, my lord.
Anyway,
Yes. And at page number 48, my lord, okay, section 2, right to be heard, my lord. So this is the procedure
Section 2 of what?
of the code, my lord, at page number 48 of the code.
No, how does this section 2 just appear like that?
It's divided into chapters, my lord. The disciplinary code of 2024 is
Where is section 1 then?
section 1 is at page 46 under chapter 4.
Chapter 4 procedure.
Yes, my lord. Under chapter 4, there's section 1 for time limits, and then section 2 for right to be heard. So under right to be heard, the party shall be given the opportunity to be heard before any decision is passed. However, there is also some provisions, my lord, other provisions. A party may, without limitation, refer to the file, present their argument in fact and in law, request production of proof, be involved in the production of proof, and obtain a reasoned decision, my lord. I was never provided any of the evidence or proof to prove my case, my lord, to have my arguments presented in fact and in law, because I was never given any details.
Proof will be from your side or from their side?
From their side. They have to give me the evidence from their side so that I can prove my case, my lord, because the burden of proof lies upon them. Thereafter, I was issued the impugn letter, my lord. And after issuance of the impugn letter, I filed my intention to appeal.
Where is the appeal provision?
The provision for intention to appeal is under Article 119.
What about 117 at page 56?
Yes, this is the, before that, my lord, before that, I have to file my intention to appeal within 3 days from notification of the grounds of notice, grounds of decision. However, I was never given the grounds of decisions. Despite that, I submitted my intention to appeal from the date of issuance of the impugn letter.
Where is that grounds of decision? Grounds of decision. You mean to say before passing these impugn orders?
Yes.
There has to be a ground of decision?
Yes, my lord. It is at page 52.
Under what provision?
Under Article 105, form and content of the decision.
So you have filed an appeal otherwise, isn't it?
Yes, my lord. I have filed an appeal
When did
on
you file?
on 9/11/2000 sorry 7/11/2024, my lord.
Where do we get the appeal?
The appeal petition is at page number 54 of my petition, my lord.
Yes, and where's the date?
A date is at the last page, which is at page number 61.
13 November.
13 November, yes. Since then, the respondents have kept quiet.
Why have you come now?
My lord, because there were other alternate remedy available before approaching the writ court, my lord. I have exhausted all the remedies available. I have also submitted my complaints to the AIFF. I have also submitted my complaints to the Asian Football Confederation. I have also submitted my complaint to the FIFA, my lord. I have done all necessary procedure, and thereafter the respondents have issued a notice to me on 6 July 2025, informing me to pay the appeal fee of 60,000, my lord, so that my appeal can be disposed of. However, I also paid the amount, my lord.
Where is that?
At annexion number 17, page number 91. If I may read, my lord.
Yes.
Dated 6 July 2025 to Johnny Ramthansanga, the petitioner, subject intimation for payment of appeal hearing fee. This is to inform you that the date of hearing of your appeal before the appeal body will be communicated to you upon receipt of the requisite appeal fee, which must be paid on or before 13 July 2025 by 11:30 p.m. Indian Standard Time. Please note that your petition for appeal shall be considered only upon submission of valid proof of payment of the appeal fee in accordance with Article 120.1.1 of the AIFF Disciplinary Code 2024, which stipulates an amount of 60,000 for an individual appellant. You have been afforded adequate time since the issuance of the disciplinary order by the Mizoram Football Association. Important instructions regarding payment of fine or appeal fee. Payment must be made to the following bank account of the Mizoram Football Association. Proof of payment must be submitted within the specified deadline via WhatsApp at so-and-so. So they provided the bank account details. For difficulties or clarifications related to the payment process, you may contact us at so-and-so. So accordingly, I paid a fee of rupees 60,000.
When?
On 13 July 2025, my lord, which is at page number 92, annexion number 18.
On the last date?
On the last date, my lord.
But within time?
Yes, my lord.
How is this transfer done? This is through online.
Yes, my lord.
But what about the timing, date and time? Date is there, time is not there. Because they have said 11:30 p.m.
Yes, my lord.
IST.
However, my lord, I would like to bring to your attention that July 13th is falling on the Sunday, which is a public holiday. So as per the AIFF disciplinary code, if I am not mistaken, the public holiday will not count, and the next day after the public holiday will be counted as the last day.
Is there any controversy on that you did not pay within time?
No, my lord, because it is written in the AIFF code, which has been used by the MFA themselves, my lord.
No, it is written, no doubt.
Ma'am.
But have they said that you have paid this appeal fee
Yes, my lord.
belatedly?
My lord, if I have been late, there's
No, is that their case? Any response from them?
no, my lord, that
Okay.
there have not been acknowledging any of my submissions, my lord. Thereafter, I also submitted a request.
So that means they have accepted your
My
appeal
lord.
fee?
My lord,
If there's no such kind of response from them saying that
You are
we are not
late.
accepting, it's late,
yes, my lord.
that means they've accepted it. But what has happened to the appeal?
Nothing, my lord. They have been silent till date. I have also submitted another request to the respondent number 7, to furnish me the grounds of decision, which is as per the AIFF code, but till date they have not given me any of the grounds of decisions taken.
What is this, page 43?
43?
This is your letter.
My lord, page 43
Yes.
of my petition?
I'm sorry, it's 94.
Yes, my lord. Page 94 is the true English translation to which I have submitted the request.
The figure 9 looks like 4, that's why I said 43. It's 94,
My lord.
93, 94.
I apologize, my lord.
Then what did you write?
I have requested the grounds of decision, my lord, so that I can be able to prepare my defense when the appeal hearing is conducted, my lord. But till date, the grounds of decisions taken by the respondent number 8 has not been furnished to me. Grounds of decisions meaning that my any evidence available on record.
Okay, see, from what I've understood, there was a complaint. There
My
was
lord.
some football matches, some season, and there was some allegation against a lot of players. One of the player of your team was summoned.
My lord,
He could not respond to that, so they contacted you.
my lord,
You, along with the player, went to the police station
my lord.
and you were interrogated. You say you denied that your involvement. Next thing is that they call you, the disciplinary body calls you, then pursuant to that, they issue this, what do you call, they list out the club's officials and players who are to be penalized, correct?
My lord,
Then separately, as per Annexure 7, you have been given a separate communication by which it says that under Article 63.2, you have been banned from playing and all that, whatever. So this happened in 4th of November,
my lord, yes.
2024. Now, question is, why did you file an appeal? Why did you file an appeal only, okay, you filed on 13/11/24, correct?
Yes, my lord.
Then they say that you have to give the appeal fees,
Yes, my lord.
and which you have deposited. And you deposited the appeal fee on
13 July, my lord.
13 July. Okay. So, you are waiting all this time after filing the appeal. Then lately they responded saying that give us that fee.
Yes, my lord.
You gave the fee, but still no response. That is why it is. So till date, you have there is no response from
No,
them.
my lord, I have not received any.
Yes. Anyone appearing?
Yes, my lord, I'll be appearing for respondent number 7 and 8.
What is the instruction?
The instructions is that, my lord, there's an appeal provisions. So they have to go with that, and the MFA is taking steps towards hearing his appeal. However, he himself told the MFA, some of the officials, that he would not be taking a lawyer, and that if my appeal should be considered, and then I will be appearing for that. And so accordingly, an appeal committee was formed by the MFA. That, my lord, I'll be submitting that.
Appeal has to be disposed within a time frame, or you can dispose it any time?
No, my lord. There is no time frame. However, there has to be an intent to appeal, which they have already submitted.
It is there.
Yes, the intent was submitted. However, the appeal, the detailed appeal was not submitted yet. And that has to be accompanied by an appeal fee, which
That is-
he has not paid on time. However, the MFA has intimated that the right to be heard be given to him, so his appeal fee was accepted. And so accordingly, this appointment order, my lord, if I may submit this.
Appointment order,
Appeal committee.
what does it say?
so that if they are unhappy with the order, this disciplinary order of the disciplinary committee, then they can appeal to the appeal board. My lord, my point is that there is appeal provisions which the MFA is actively taking steps towards that, and he is the only one who has paid the appeal fee. And so, my lord, for that, he has to submit the appeal petition, which he hasn't done so. He has just sent the intent to appeal. That is within 3 days.
No, this is not an appeal.
No,
What
my
is
lord,
it?
there is appeal provisions. My lord, if I may take you to the appeal provisions.
No, you please come to page 54 of the writ petition. You have a copy of the writ petition?
Yes, my lord.
What is this? Is this not an appeal?
No, my lord, these are the intent to appeal.
Is that so?
Yes,
Intent
my
to
lord.
appeal.
My lord, intention to appeal is at page number 52, my lord. Annexion number 8. So the intention to appeal has to be filed within 3 days from the date of receipt. So within 3 days, we have submitted the intention to appeal.
7
my lord,
November.
at page 52 of my petition, annexion number 8. So thereafter,
Who are these name here? Regards so and so, so and so. At page 53. Signatories, who are these?
yes, these are the previous counsels engaged by the instant petitioner, my lord.
Okay.
So thereafter, during the time frame, we even submitted the appeal petition, which is at page number
Okay,
54.
4th July is the list of clubs, officials and so penalized.
4th November, my
And,
lord.
4th November.
Yes, my lord.
Then separately, 4th November, there's a letter to you.
Yes, my lord.
Then as per the provision, you have to give that intent to appeal within
Yes,
3
my-
days.
Yes, my lord.
And 4,
However, my lord, I
5,
would,
6, 7. On 7 November, you submit that.
yes, my lord.
Then,
So, my lord, after, I was given 10 days to lodge my complaint to the, my lord, if I may have your attention to page number 51, the impugn letter issued by the respondent number 8, my lord. At last paragraph, you are hereby informed that appeal against the penalty can be lodged to the MFA Executive Committee through the Honorary Secretary before the lapse of 10 days on issue of this letter. So, from 4th to 10 days, during the 10th day, we have submitted our intention to appeal on the 7th of 11, and on the 13th of November 2024, we even submitted the appeal petition. And regarding the appeal fee, we were never informed of paying the appeal fee or the amount to be paid. The only appeal fee to be paid intimated to us was on the 6th of July 2025.
okay, so
That-
page 54 is your appeal.
Yes, my lord.
This is not intent to appeal, this is the appeal, in fact.
Yes, this is the appeal
What is
However,
petition.
my
your-
lord,
What is your
this
prayer?
cannot be accepted as appeal, because if we go to Article 120 of the AIFF Code, my lord, if I may take your lordship's attention to page 58 of the AIFF Code. Article number 120.
Yes.
Appeal fee. All appeals shall be accompanied by an appeal fee of rupees 60,000 in the case of an individual appellant. That, my lord, it is clearly written here.
Okay, that has been
And
taken care
they,
of.
yes, not knowing the law cannot be an excuse, my lord.
No, that has been, they have deposited 60,000 now.
But they deposited at the very latter stage just last month, on the 13th of July.
So what do you intend to do? You intend to reject their appeal?
No, my lord.
You consider their appeal?
Yes, we are considering. That's why we are setting up the, which I had submitted before your lordship.
Ah.
That is the appeal committee.
This is 4th July.
Yes, my lord.
We are on 19th August now.
Yes, my lord, there is another appeal pending, which is passed, today it's listed as item number 3, and there's another one which was already disposed by this honorable court, a different bench. So in that as well, there is a directions that an appeal committee be set up. So in compliance of the High Court's order, then an appeal committee was set up. And then the appeal, all their appeals, even though if it's at a latter stage, will be heard. That, my lord, as long as they pay the appeal fee. and the instant petitioner is the only one who has paid the appeal fee. However, he himself had informed that he will not be taking a lawyer, and so it's a special case. So that, my lord, a special consideration was going to be made for him. However, now they had filed an urgent case. However, my lord, this is not urgent because the disciplinary order was conveyed to them on 4th of November. And my lord, after almost 1 year, they are coming because MPL season 12 is going to be starting on 21st of August.
Okay, so you consider the appeal and dispose it of within a time frame?
Yes, my lord.
Dispose it of.
My lord, if I may. Yes, my prayer is that,
What is your prayer?
yes, my prayer is to set aside the 4th of 11 impugned letters and the notification, and, my lord, to dispose of the appeal petition without payment of the appeal fee and to refund the appeal fee of rupees 60,000 paid to the respondents, my lord. If I may go by...
Why?
If I may
You don't want to go by the
technicality,
provision?
Yes, my lord. If I may have your lordship's attention to page number 51, my lord,
51 of?
of my petition, my lord, annexion number 7.
Yes.
Now, the respondents have invoked the AIFF disciplinary code, my lord. So, if I may read the last paragraph again. You are also hereby informed to appeal against the penalty. Informed that appeal against the penalty can be lodged to the MFA Executive Committee through the Honorary Secretary before the lapse of 10 days on issue of this letter. Now, if we are going to go with the appeal, if I may have your lordship's attention to page number 56 of the AIFF disciplinary code.
Yes.
Page number 56, article number 117, appeal. An appeal may be lodged to the AIFF Appeal Committee against any decision passed by the AIFF Disciplinary Committee as well as the Player Status Committee except 117.1.1, where the sanction imposed is a warning, a suspension of less than 3 matches or up to 2 months without exception of doping-related decisions, a fine of less than 4 lakhs imposed on a member association or a club, a fine of less than 2 lakhs imposed on other legal or natural persons.
Yes, what do you want to say?
What I want to say is that, my lord, the appeal has to be lodged to the MFA Executive Committee, not the AIFF appeal body, my lord, appeal committee. So 120, they have invoked the article 120, which is at page number 58, for payment of the appeal fee of rupees 60,000, my lord. This 60,000 appeal fee has to be paid to the AIFF appeal committee and not to the MFA Executive Committee. They are totally different entity, my lord.
My lord, if I may reply to that.
No, just a minute. Your appeal is to the MFA Executive Committee.
Yes, has to be as per their instruction, my lord. It has to be lodged to the MFA Executive Committee and not to the AIFF Appeal Committee. So if I am to pay the 60,000 to the Appeal Committee, it has to be before the AIFF Appeal Committee and not to the MFA Executive Committee, my lord.
Then why did you invoke 117 in your appeal? You yourself have stated, as per Article 117 of AIF Disciplinary Code. Is there a separate set of rules for the MFA?
There has to be, my lord, as per the
No, there has to be, there is not,
as of now, they have only recently launched their code, my lord. I think it was on 31st of May, if I'm not mistaken. But at the time of my case, the AIFF disciplinary code was only the only code available. So the code introduced later on cannot go retrospect to my case, my lord.
So you have invoked 117 of the AIFF Disciplinary Code, wherein the prescription is deposit of 60. You have complied with that, you have deposited. Now you say that no, you want a refund because we are not talking about AIFF, we are talking about MFA. How can that be? What about the other cases? Who's going to settle that case? There's one more case listed today.
My lord, yes.
And previously also there's one case disposed of, isn't it?
Yes, my lord.
And direction was given to whom? MFA or to the AIFFA?
To the MFA, my lord.
And what was the provision invoked for the appeal?
117, my lord.
Same thing. So how does it differ from that case?
The difference is that in the previous case, my lord, the petitioners confessed to the crimes, my lord. In this case and the next case...
No. Did you pay 60,000? Did they pay 60,000?
No, my lord.
They did not pay.
No, my lord. They have not paid.
Why is that?
Because, my lord, due to the financial restrictions caused upon them due to the actions of the respondents in not allowing them to participate not only in the upcoming MPL but also in all other activities involving football or its related activities such as futsal. They are not allowed to even participate in local tournaments, my lord. The only source of income they have has now been restricted by the respondents. They have told them you cannot play football anymore. So when that happens, there is some financial restrictions going on.
See, you take your pick. Firstly, like I said, we
My lord.
ask the authority to consider your appeal and dispose it of within a time frame.
My lord.
If not, if you dispute that this AIFF rules doesn't apply to you, they will have to issue notice and take a decision
My
at
lord.
some point of time, which will take some time.
My lord, if I may take your lordship to page 13 of the AIFF code, article 5.
Yes.
If I may read, member associations disciplinary regulations. Member associations are directed to adapt their provisions to this code so as to standardize the disciplinary regulations, else this code shall prevail with required modifications. In case of conflict, the provisions of this code will apply. That, my lord, this code is applicable. And also, my lord, if we look at Article 3, scope of application, in page number 12. 3.11, AIFF member associations. 3.12, members of member associations and their affiliates. MFA is a member association who affiliated to AIFF. That, my lord, so there is no question as to the operation of this code.
Okay.
And also, my lord, the AIFF is not the appellate body. The judicial bodies has to be set up by the same state, by the same body, which my learned friend has already read out before in the judicial bodies.
Where was that judicial body? Right to be heard.
Article 71, my lord.
71. Yes, judicial bodies.
Here as well, my lord, it's under the AIFF only that all these judicial bodies are set up. AIFF Disciplinary Committee, AIFF Players Status Committee, AIFF Appeal Committee. So likewise, my lord, the MFA has set up the Disciplinary Committee, and also the Appeal Committee is set up again.
The disciplinary committee is not a permanent committee, or what? Depending on the requirement, the committee
Yes,
is
my
formed.
lord. Because per sitting, they have to pay for their per sitting allowances as well. So,
Okay, sitting allowances are there.
yes, my lord, to heard the appeal. And also, my lord, there is also, my lord, my one submission is that MFA is not a state or any other authorities under Article 12 of the Constitution. No funding is received from the state government except for a yearly promotional fund, which is around 17 lakhs per year. So, my lord, that it cannot be said that MFA is a state or any other authorities as per section Article 12 of the Constitution. So therefore, my lord, there is an appeal provisions, and so, my lord, this writ may be dismissed.
Do you dispose of the appeal within a time frame,
Yes, my lord.
within a month?
Yes, my lord.
My lord, if it may be disposed of within 2 weeks, my lord, because we have waited since November arbitrarily. So we have no alternative remedy but to approach this court. So at the last resort, we come before your honor, your honorable court, my lord.
Okay, please write down. Heard, Ms. Valentina Naldin-Pui, learned counsel for the petitioner, who submits that by filing, learned counsel for the petitioner, Ms. Lalngai Sakifan Nai, learned counsel. You are engaged
Yes, my lord.
specifically for this case.
Yes, my lord. Not the standing counsel.
Learned counsel for respondent number 7 and 8.
Yes, my lord.
Ms. Varnesiami, learned government advocate for respondent numbers 1 to 5. And who is 6?
This is the
AIFF.
AIFF, my lord.
Stop. Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at the motion stage itself. Full stop. Next paragraph. The petitioner, who is the vice president of FC Bethlehem, a football club affiliated under the respondent number 7, being aggrieved with the list of clubs, officials and players penalized by Mizoram Football Association (MFA), dated 4/11/2024 (Annexure 6), wherein his name appears at serial number 3 of the officials who have been banned from all and any football-related activities for 3 years, and also the decision of the Disciplinary Committee dated 4/11/2024 (Annexure 7) has filed the instant writ petition praying for setting aside of the 2 impugned communications. Next para. Brief facts of the case as projected by the petitioner is that based on a complaint received by the based on a complaint received from the Honorary Secretary, MFA, with regard to the suspicion on match fixing. In the recently held Mizoram Football League bracket MPL 11 close bracket conducted by MFA the appointed investigating officer, Aizawl Police Station, submitted his inquiry report. Wherein the name of the petitioner was also mentioned. Stop. Thereafter, the Secretary, MFA Disciplinary Committee, wide communication dated 29/10/2024, summoned the petitioner to appear in the MFA office on 31/10/2024 at 1:15 p.m. to tender his explanation on the allegation. To stop, the petitioner accordingly appeared on the date fixed and pursuant thereto, the impugned list dated 4/11/2024 and the communication dated 4/11/2024 of the Disciplinary Committee was issued banning the petitioner from taking part in any football-related activities for a period of 3 years, and the time period will be from 4/11/2024 up to 2028-2029 seasons. Stop. It was also indicated that the MFA will ensure that the penalty is enforced not only within Mizoram but throughout the entire territory of India, wherever the jurisdiction of the All India Football Federation bracket AIFF applies. Stop. The petitioner was also informed that an appeal against the penalty can be lodged by him to the MFA Executive Committee through the Honorary Secretary within a period of 10 days from the date of issuance of the letter dated 4/11/2024. Stop. The petitioner, through his counsels, submitted his intention to appeal against the penalty that was imposed upon him on 7/11/2024, and thereafter filed his appeal on 13/11/2024. Stop. Despite filing of the appeal, no further steps was taken by the respondent authorities concerned. And finally, the petitioner on 6/7/2025 was informed to deposit the requisite appeal fee of rupees 60,000 on or before 13/7/2025 by 11:30 p.m. IST in accordance with Article 120.1.1 of the AIFF Disciplinary Code 2024. So, stop. The petitioner deposited the said amount on 13/7/2025 through online. And thereafter submitted an appeal and also submitted a letter before the Honorary Secretary, MFA, on 16/7/2025. Stop. Since no further steps have been taken thereafter, the petitioner being aggrieved is before this court. Stop. Next para. Ms. Valentina Laldinpui, Learned Counsel, submits that the petitioner has not been given sufficient opportunity by the respondent authority concerned to defend himself on the allegation that was made against him. Since no written grounds of complaint was given to him, she submits that as per the decision of the disciplinary committee, the petitioner was informed that he can file an appeal before the MFA Executive Committee through the Honorary Secretary within 10 days from 4/11/2024, and which the petitioner accordingly did. Stop. There was no mention about submission of any appeal fees at any point of time, except on 6 July 2025, after a considerable delay. To stop, she also submits that the appeal fee of rupees 6,000, although deposited by the petitioner, should be refunded to him, since appeal has to be heard by the appeal has been filed before the MFA authorities. MFA Executive Committee through the Honorary Secretary. And the prescription of depositing of rupees 60,000 as appeal fees is otherwise under the AIFF Disciplinary Code. Stop. She therefore submits that the impugned list dated 4/11/2024, insofar as the petition is concerned, and the disciplinary committee and the decision of the disciplinary committee dated 4/11/2024 should be set aside. Next para, Ms. Lalngai Sakifanai, Learned Counsel, at this stage appearing for respondent numbers 7 and 8, submits that the writ petition is not maintainable in view of the fact that the MFA does not fall within the definition of estate under Article 12
Yes,
of the
Madam.
Constitution of India. Since no fund, direct or indirect, is received by the respondent number 7 and 8 from the government.
Well, except for around 17 lakhs as promotional fund.
Except
Yearly.
for a
17.
meager amount of 17 lakhs as a promotional fund. To stop, she therefore submits that the writ petition should be dismissed on the grounds of non-maintainability. Stop. She further submits that as per what do you call this article?
Yes, my lord. AIFF
They are called articles.
code. Yes, article.
As per Article 3 of the AIFF Code 2024, the scope and application of the code extends to all AIFF member associations, such as the respondent number 7. So Article 5 of the code further provides that member association are to adapt their provisions to this code so as to standardize the disciplinary regulations and in case of conflict, the provisions of the Code of 2024 of the AIFF will prevail. To stop, it is therefore clear that there is no second opinion about the applicability of the Code of 2024. Insofar as respondent number 7 and all the clubs affiliated to it Stop. She further submits that Article 120 of the code provides for an appeal fee of rupees 60,000, which the petitioner failed to pay at the time of filing his appeal. Stop. Since the same has been clearly specified in the code, the petitioner cannot plead ignorance of the same. Stop. At any rate, the learned counsel submits that pursuant to the appeal and the deposit made by the petitioner towards appeal fee, the respondent number 7 has constituted an appeal committee on 4/7/2025, comprising of chairman, deputy chairman, and a member. Stop. He therefore submits that pending consideration by the appeal committee, no cause of action arises and the writ petition should be dismissed. Ms. Vanesyami, learned government advocate, also adopts the argument made by Ms. Lalngai Sakifanai. Next para. Having regard to the nature of grievance projected, the penalty imposed and the provision wherein the party aggrieved can seek remedy by way of an appeal has been provided, this court is of the considered view that without entering into any of the controversies, it would meet the ends of justice if the respondent authorities, through their constituted appeal committee, consider the appeal filed by the petitioner as expeditiously as possible. Since the constitution of the appeal committee has been done as far back as on 4th July 2025, and at the same time the appeal having been filed by the petitioner on 13/11/2024, let the appeal of the petitioner be considered and disposed of within a period of 1 month.
My lord, 2 weeks. In the meantime, my lord, I would like to make one submission. I have time and again submitted in my complaints and my requests to provide the grounds of decisions, my lord, and request for production of the proof for which I am to prepare my case. Without that, I cannot prepare on what ground am I supposed to produce any evidence for myself. So if direction may kindly be given to the respondents number 7 and 8 to furnish me a copy of the evidence so that I can prepare my case for the appeal hearing.
My lord, if I may reply
As
to
per
that.
the AIFF code, my lord.
My lord, if I may take again your lordship's kind attention to Article 106 of the code,
What does it
decision
say?
without grounds. The judicial bodies may decide not to communicate the grounds of a decision and instead communicate only the terms of the decision. At the same time, the parties shall be informed that they have 10 days from receipt of terms of the decision to request in writing the grounds of the decision, and that failure to do so will result in the decision becoming final and binding and not appealable. However, my lord, he himself had stated to members of the MFA and some of the disciplinary committee members that he is not engaging a lawyer and that he would not even ask for the grounds of decision.
Okay.
So that, my lord, regarding
as
that,
per-
if they make an application for grounds of decision, then definitely we will reply to that.
My
So
lord,
that
as per...
that is exactly what I'm going to say.
Yes,
Okay. I've noted your points, okay.
Yes, my lord.
It is it is further provided herein that the petitioner is given liberty to apply for the grounds for the allegation and such documents as may be relevant in order to enable him prepare himself for the appeal hearing by submitting an application before the General Secretary
Yes, my
of
lord.
MFA,
Honorary Secretary.
Honorary Secretary. And in the event of such application being filed within a period of 1 week from today.
My
Okay.
lord, we have already filed
When?
on the first instantion of appeal,
Okay.
on the appeal petition.
Okay, 1 week from today, if not already filed, the respondent authority concerned shall consider the same in accordance with law and take a decision. With the above observation and direction, the petition stands disposed of. So everything is open.
My lord.
If you want to submit one more, you submit your application. If you say that that will be suffice, it's up to you.
My lord.
Okay?
Your Lordship, if I may, regarding the allegation, it is very clear from the inquiry report submitted by the concerned police.
No, it's okay. They want some more
So if they
materials,
want to
let
make
them ask for it.
explanation, if they want-
You are also free to deny them, it's up to you. I'm not saying anything. If you say it's enough, you say it's enough. You reply like that.
My lord.
But if you want to give, you give. It's open,
So, my lord, the appeal will be disposed of within 2 weeks?
within 1 month.
Yes, my lord. We will
It
definitely.
takes time, you see.
My
People
lord, the
are-
body has already been formed and we have already made the
I
payments.
know the body is formed, but I'll give them 4 weeks' time because
4 weeks,
it has to be reasonable time, you see. You also have to prepare yourself.
my lord.
Okay, next
Obliged.
case.
Obliged.
Orders, item 10.
TCR has come. What is
Yes,
your
Lordship, we require a paper book.
Yes, may it please your lordship, yes, the note sheet has reflected that the LCR have been received, so the...
Not LCR, TCR.
TCR, yes.
Trial court records.
Yes, Lordship.
Henceforth, we have to say trial court records. Okay?
Yes, I remember
We
that.
have to get used to that. Parties are represented by the respective councils and they submit that. Preparation of paper book will be required. Full stop. It is seen that the TCR has been duly received and therefore registry to prepare paper book and expeditiously at the cost of the appellant and thereafter list the matter for orders once copy is served to the parties concerned.
Obliged.
Much obliged.
Item 11.
May it please your lordship. My lord, if I may be allowed to file my affidavit in opposition by tomorrow, my lord. Everything is ready now.
Affidavit in opposition,
Yes, to
On-
the IA filed to the condemnation, delay petition, my lord.
delay condonation.
Yes, my lord.
Okay. Yes, you file. When will you file?
By tomorrow, my lord.
By
Everything is
tomorrow.
ready.
Mr. Lalbiak Nunga, Namte, Learned Counsel for the respondents,
Yes, my lord.
submits that the objection to the application for condonation of delay is under preparation and he'll be able to file it within 2 days. In view of above, list this matter again after a week.
Deeply obliged, my lord.
Much obliged, Lord.
Admission, item 2.
Yes, yesterday's matter.
Yes, my lord.
My lord, the matter may takes a little longer time. If your lordship permits me, I may start with.
Yes, please. Miko.
Can it be some other day, my lord, because I have to leave also a little early today.
You have a plane to catch.
Lordship, my lord, 2:30. And I don't think the time would permit to complete the matter. And otherwise also, my lord, two things I have said, my lord, yesterday regarding the maintainability and secondly, the ground urge with regard to my certificate. If they wishes to make any party, in that case, time will otherwise they have to, my lord, take, I don't know, subject to what he feels, whether to add him or party or not.
Nobody is praying for that.
Yes, so, my lord,
So why
that
should
is
we
there.
grant time like that?
Lordship, so that is there, my lord. Oh,
I think I have heard more or less the parties. What is there? What remains?
No, my lord, actually they have raised some few points, my lord. First point they have raised, my lord, as the learned counsel had mentioned, is the non-implement of necessary parties, my lord, the maintainability aspect. My lord, that I'll have to reply also.
Of course, you'll reply.
Yes.
We'll give you a chance for reply.
Yes.
And Mr. Saike has already finished.
My lord,
What else
so,
do you have to
my
say?
lord, in nutshell, I have made my submissions, my lord, yesterday. Now, just want to elaborate 1 or 2 points, my lord, with regard to the interpretation of that particular rules. Because whatever the judgment, those have been, my lord, cited. My lord, 1 or 2 yesterday I have said that these are not applicable. Even the 2 judgment, one is of the Bombay High Court, full court judgment of Bombay. And secondly, one is of 2018. Both are in a different facts, my lord. In so far as the my lord, the full court judgment of the Bombay High Court is concerned, the rule is absolutely silent. It doesn't give any indication. It doesn't have any provision. In that context, in the said judgment itself, it has been said that the state has the power to make the rules. But in absence of such rules, we cannot presume that the person can claim this concept of cumulative the age relaxation. But here in our case, we have a valid rules, and Rule 5 makes it abundantly clear that apart from the relaxation the rule has given with regard to the departmental candidate, he is also entitled to the relaxation so far as the reserve category candidate is concerned. But if I may, the judgment. No, this one, MPSC, Maharashtra Public Service Commission. Well, I am holding a citation from AIR online that Maharashtra Public Service Commission, perhaps my friend has submitted with regard to Maharashtra Law Journal. There may be little. No, I'm referring to, my lord, his judgment, what he has to do. We have given our list of books.
You're referring to his judgment?
His judgment, only for the purpose of distinguishing, my lord.
Which case?
This is Maharashtra Public Service Commission.
Yes.
In this Maharashtra Public Service Commission,
See, Mr. Saikia, there's some time constraint.
Lordship, my
If you can stay back, it's well and good.
Lordship.
Otherwise,
Yes, my lord, I have to leave, my lord. I have to leave, my lord.
you have to leave.
I believe some
You have
fixed
to leave.
matters are there in Guwahati tomorrow.
So what will you do? You'll come back again? What is to be done? Or your friend will take over?
I may come back again, as your lordship pleases. Or I can conclude my part, and then if any reply is required, then for a different date, so my friend can.
No, how long can you reply?
Lordship, my lord.
Audience is given to the petitioner, then you reply. I mean, you counter that.
No, in case.
Then
in
there's
case
a short reply from him. That's it.
That's it, my lord.
Otherwise, after hearing him, again we give you chance, again he will want to be heard. So this will be a never-ending process.
That is true, that is true, my lord. So, my lord.
No, if you can conclude, it's well and good, but if you have difficulty saying that I need to elaborate more, then of course it's up to you. But keeping this matter for a long time will not be advisable,
That is there, my lord.
because bench is here only for 2 weeks.
My lord,
Or perhaps, my lord,
so we'll continue, my lord, to the extent I can, my lord, today. To the extent I can today, my lord, I'll be continuing, my lord. The
Okay.
rest, my friend will take.
All right, all right.
take care, my lord. So far as these two judgments, my lord, I have said, my lord, MPSC, my lord.
Yes, Maharashtra Public Service.
Lordship, my lord. My lord, these two, my lord, judgment, so far as the Maharashtra is concerned, my lord, there are absolutely, my lord, no rule, my lord, indicating, my lord. That your lordship will find my lord, consideration of the submission of and case laws, my lord, this will be in the paragraph 26. As noted earlier, the main issue involved in this reference is whether, in absence of any indication in the rules, executive instructions, provision for age relaxation should be considered on cumulative or non-cumulative basis in respect of applicants who are covered under more than one category for which age relaxation may have been provided. So that was the, my lord, issue before the court, my lord, 26. Then your lordship may come to paragraph 39. In that case also it has been said, my lord. Paragraph 39. From the aforesaid it flows that decision on issue like whether to provide any reservation or relaxation at all, or what should be the quantum, scope or extent of such reservation or relaxation, or what should be the manner in which such reservation or relaxation be granted, are all issues which essentially fall within the realm of legislative or executive policy. In the issue of reservation, a stable equilibrium between justice to the backwards, equity for the forwards, and efficiency for the entire system has to be examined on the facts of each case, and these are not matters which can be left to be decided on the basis of any default or implications.
Yes, please continue.
So this is, my lord, so far as, my lord, that judgment also, my lord, first I said the issue is totally different, and secondly, my lord, that judgment also affirms that it is within the state. If the state makes a policy, reservation, quantum, the manner, taking into various factors, they can. But as because there was no, my lord, rule as such or the executive instruction operating giving this, my lord, relaxation together. So therefore, the court has decided the reference that in absence of any rules or executive instruction, the cumulative effect cannot be given, my lord. That is one, my lord. Then secondly, my lord, he has another based this, my lord, argument on the basis of this 2018-11 SCC, Gaurav Pradhan versus State of Rajasthan. My lord, here factually totally different, my lord. That facts your lordship will find even in the, my lord, head note itself. It will be page 353. My lord, there what happened, a rule was operating which says that if a candidate avails the any relaxation or concession, in that case, even if he turned out to be securing more marks than the open category candidate, he will not be able to migrate to the open category. While that notification was in operation, advertisement was issued, the process of the recruitment has initiated, then a further instruction circular came to be issued by the state government, whereby it said that if a reserve category candidate, even if he avails the relaxation, but he comes in the merit, then he will be considered as a open category. He can migrate to the open category candidate. The issue is also not directly, my lord, what the issue here in this petition. That was basically an issue whether when, my lord, the both posts are there, that is for the reserve category as well as the general category. So a reserve category candidate, while availing one of the age relaxation or something like that, and if he comes out to be the, my lord, in the competition, my lord, his marks turn out to be the higher than the open category candidate, then he or she will be placed in that. So this was the second notification. That notification came to be challenged, and the court has found, since the recruitment process started while the earlier rule was prevailing, so the recruitment process has to be conducted under the earlier rule and not by the subsequent rule, which provides for migration of the reserve category candidate into the open category candidate. This is at page 353, the head note itself, my lord, instead of going to the relevant paragraphs, if I am permitted to read, my lord.
Yes.
Placita E, my lord, page 350. The Rajasthan PSC issued advertisement dated 14/10/2010 for selection to various posts of constable, and another dated 25/10/2010 for selection to the post of sub-inspector of police. During process of selection, the state government issued circular dated 11/5/2011, providing that candidate of BC, SBC, SC and ST, irrespective of whether they have availed of any concession, including relaxation in age, shall be migrated against open category vacancies if they have secured more marks than the last candidate of open category. Select list of constable was issued on 1/7/2011, whereas the result of sub-inspector of police was issued 25/2/2003. Various writ petitions were filed by general category candidates challenging the circular dated 11/5/2011 and preparation of select list accordingly. The single judge, by judgment dated 27/4/2012, held that only those who had taken benefit of concession of a fee and not relaxation of age during the process of selection would be allowed to migrate to open general category if obtained equal or more marks than the last candidate in open or general candidate. The other group of writ petition was decided by the single judge by judgment dated 8/11/23, following the judgment dated 27/4/2012. The division bench disposed of all the special appeals by modifying the judgment of the single judge dated 27/4/2012 and 8/11/2013 to the extent that all relaxation in age having been availed by candidate of reserve category who find place in the select list on dint of merit of general open category vacancies deserve to be migrated against general open category vacancies. However, candidates availing special relaxation concession while participating in competitive test process selection if find place in select merit list of the general open category vacancies, they were not eligible to migrate against open general category vacancies. Agreed by the aforesaid judgment, all the appeals have been filed. The issue arose for consideration whether the reserved category candidate who had taken benefit of age election in the selection process in question and have obtained marks equal or more to last general category candidates would be treated in general open category candidates or ought to have been confined in the reserved category candidate, and whether the circular dated 11/5/2011 issued by the state government challenging the criteria for migrating reserved category candidate into general category candidate can be applied in respect of the selection, which has already begun on issuance of advertisement dated 14/10/2012 and 25/12/2012. Now, the decisions, my lord. Page 47, paragraph 47. In paragraph 47, the circular to the government shall be treated to be in force for the purpose of reservation which is force at the time of recruitment. Recruitment commences by the advertisement dated 7/10/2010 and 25/10/2010. At that time, only the circular dated 24/6/2008 was in force. Hence, the subsequent circular dated 11/5/2011 cannot be applied in the present recruitment. There cannot be any dispute that the policy of reservation can always be challenged. I am referring to paragraph 47.
Yes, this way.
I'll just read again, my lord. It starts with the circular of the government. The circular of the government shall be treated to be in force for the purpose of reservation, which is in force at the time of recruitment. Recruitment commenced by the advertisement dated 7/10/2010 and 25/10/2010. At that time, only the circular dated 24/6/2008 was in force. Hence, the subsequent circular dated 11/5/2011 cannot be applied in the present recruitment. There cannot be any dispute that the policy of reservation can always be changed by the state government, and the state government can change the manner and methodology of implementing the reservation and criteria of reservation of the reserved category candidate and general category candidates. It is also relevant to note that both learned single judge and the division bench have not approved the circular dated 11/5/2011 too. Both the count have held that apart from the age election, if candidate has taken other relaxation, the circular dated cannot help him in migrating into the general category candidate. So, my lord, since the advertisement was in force, that was the circular dated 24/6/2008, that did not give any, my lord, scope for migration. But during the process, this 5/11/2011 has come, so therefore that cannot have any implication. But nonetheless, my lord, it has affirmed that state has the power. So, my lord, that what, my lord, the judgment he has cited. Now, so far as our case is concerned, Lordship has seen the rules. My lord, once again, my lord, page 82, my lord, that rule 5, it is in the nature of, my lord, non-obstante clause. The language is akin to the effect of a non-obstante clause, my lord. Page 83. Nothing in this rule shall affect reservations, relaxation of age limit, and other concession required to be provided for the candidates belonging to the scheduled caste, scheduled tribe, other backward classes, ex-servicemen and other special categories of person in accordance with the order passed by the central government from time to time in this regard. So even the rule would have said, any provision of the rule would have said that he is not entitled to cumulative. Then also, this has a overriding effect of all the rules what is there, my lord. My lord, what is a non-obstante clause, my lord, that has been, my lord, discussed by the apex court, my lord, has decided, my lord, in the judgment of this condition. Now, this is 1984 supplementary SCC 196. GM
1984?
Supplementary SCC 196.
Paragraph?
Paragraph 10. Union of India versus GM Kokil. Let's straightway come to page 203, third line from top window.
Yes.
It is well known that a non-obstante clause is a legislative device which is usually employed to give overriding effect to certain provisions over some contrary provision that may be found either in the same enactment or some other enactment. That is to say, to avoid the operation and effect of all contrary provision. Thus, the non-obstante clause in section 17, namely notwithstanding anything contained in the act, must mean notwithstanding anything contrary contained in the act. As such, it must refer to the exemption provision which should be contrary to the general capability of the act. So that is the meaning of the non-obstante clause, which is the mentioned in the Rule 5. So therefore, my submission, this here, so far as the Rule 7 is concerned, it prescribes the qualification and required selection, and the annexure at page 161 clearly says that for the departmental candidate is, my lord, relaxable by 5 years, so it is 35 years. And the advertisement also, my lord, in clause 25 clearly spells out, my lord, that any age relaxation that is, my lord, as per the circular of the central government. That clause, your lordship may come to see, my lord, page 204. And relevant clause is at page 207. Clause number 25. This clause refers to, my lord, Rule 5. Because there different categories are mentioned. Here, my lord, it is not a, my lord, the departmental candidate are not a category. Rather, my lord, by this advertisement, by this rule, they are seeking direct, my lord, recruitment from two pools. One is the open category and the other is departmental candidate. It is applicable to everybody, irrespective of SC, ST, physically disabled, etc., whatever, my lord, this is applicable to everybody if he is a departmental candidate. So it's a clear indication, or rather it is a clear provision, my lord, which says that over and above this, my lord, relaxation of the departmental candidate, as per Rule 5, they are also entitled to the raise relaxation for the reserved category candidate as per the memorandum which have been annexed, my lord. And that's what the, my lord, the NIT has, my lord, corrected itself. Initially, they have, I said, my lord, they did not accept that, but subsequently they have corrected to it, my lord. Now, my lord, when the language is very plain, my lord, language when, my lord, is, my lord, very plain, my lord, what would be the literal interpretation of the rule is the best interpretation. That was, my lord, the Supreme Court time and again said. My lord, I'm just referring to one of the judgment, 2021-8 SCC, page 1.
Page 1.
Page 1, my lord.
Which paragraph?
There's a little confusion, my lord. I am holding this AIR basically, my lord. But this starts with just find out. But in the air, it is the sentence, the paragraph starts with before making upon the exercise of
Parties are same. Jayashree,
Jayashree, my lord.
Lakshman Rao.
Lordship.
It starts from which
My lord,
paragraph?
my lord, these are paragraph 201, my lord,
201.
in the SSC.
201.
201 in the SSC, paragraph 201. Page 116.
Yes.
201. Before embarking upon the exercise of construing the above article, it is necessary to refer to the cardinal principle of interpretation of the Constitution. Constitution is intended to endure of age to come and consequently to be adopted at the various crises of human affairs. We must not forget that it is the Constitution we are expounding. The Constitution is living organic document which requires to be construed broadly and liberally. I am reminded of the word of caution by Benjamin Carjo, who said that a judge is not a knight errant roaming at the will in pursuit of his own ideal of beauty or of goodness. Judges is not to innovate at pleasure. Rules which are applied to the interpretation of other statutes apply to the interpretation of the Constitution. It may be desirable to give a broad and generous construction to the Constitution provision, but while doing so, the rule of plain meaning or literal interpretation, which remains the primary rule, has to be kept in mind. In fact, the rule of literal construction is the safe rule even while interpreting the Constitution, unless the language used is contradictory, ambiguous, or lead really to absurd results. The duty of the judicature is to act upon the true intention of the legislature. The Mans of Senecia legacies, the 202, the first and primary rule of construction is that the intention of the legislature must be found in the words used in the legislature itself. Oliver Wendell Holmes Jr. has famously said in a letter, "I do not care what their intention was, I only want to know what the word means. If the if the language of the meaning of the statute is plain, there is no need for construction as legislative intention is revealed by the apparent meaning. Legislative intent must be primarily ascertained from the language used in statute itself. Then 204, my lord. It is cardinal principle applicable to all kind of statute that you may not for any reason attach to statutory provision a meaning which the word of that provision cannot reasonably bear. If they are capable of more than one meaning, then you can choose between these meanings, but beyond that, court must not go. Then, my lord, paragraph 211. All the paragraphs are 11. I am just, my lord, in fact, 2012 to 2013. 2011, in case of ambiguity, this court has adopted a purposive interpretation of statutory provision by applying rule of purposive construction. In the instant case, the deliberation before select committee and its report and the parliamentary debate were relied upon by the respondent in their support to asseverate the object of the Article 342A is to the effect that the power of the state legislature to identify socially and economically backward classes is not taken away. Previous so request to be interpreted accordingly. So, my lord, this is the rule of interpretation. My lord, the interpretation. Firstly, the plain reading has to be given to the words, and then, my lord, if at all some ambiguity, my lord, here whole ambiguity has come up because of the, my lord, the various, my lord, the judgment has been produced. Although these are not matching to the, my lord, actual issues involved in this case. Otherwise, without taking into consideration any of the judgment, if your lordship first, my lord, read the, my lord, the rules, my lord, it is very clear. Rule 5 makes it abundantly clear that even if some restraint provision is there within the rule itself, that will also be overridden by the particular rule of Rule 5. So, therefore, the age relaxation for the, my lord, this reserved category candidate has to be, my lord, given, my lord. Then your lordship may come to another decision, my lord. Yesterday I have referred to, my lord. It is 2016 4 SCC 179, Richa Misra.
Two 2016 4
2016 4 SCC 179.
179 paragraph
24 to 29.
24 to 29.
24 to 29.
This is regarding
My lord, this is, my lord, factually I have yesterday also I have my lord, stated the facts are in, my lord, paragraph 5, 6 and 7. The facts is such, my lord, she was a departmental candidate. She applied for the DSP post and she claimed the relaxation of the 5 years. But while, my lord, she was not selected, she, my lord, challenged that before the High Court, and it was found that the rule under which she was claiming the departmental age relaxation was not applicable to her, because post was of, my lord, under the rules of 2000. She was claiming the benefit under the 2005 rules. Under 2000 rules, there was no provision for departmental candidate. And 2005, this has been incorporated. She was claiming under 2005 rules. So court says, no, you are, since the the recruitment would be governed by the, my lord, 2000 rules, the appellant was not entitled to it. That's the fact, my lord. Paragraph 5. May I permit it to read, my lord?
yes.
Well, I'll just come for the my lord, facts first, my lord. The appellant herein had applied for the post of DSP and appeared in the preliminary examination which she duly qualified. On the basis, the appellant filed the form for appearing in the main examination. In this form, she stated she is entitled to relaxation of 10 years in upper age limit being a woman. She Such a relaxation was claimed on the basis of the 97 rules which were brought into force with effect from 7/2/1997. Rule 4 thereof provides for such an age relaxation for the purpose of rule so-and-so, so-and-so. Rule 6, the appellant was allowed to participate in the main examination and she qualified that as well. Accordingly, she was called for an interview on 12/4/2007. Final results were declared thereafter. She obtained 54th position in the merit list. Thereafter, CPSC prepared the list of selected candidates and sent that list to the government for effecting appointments as per that list. However, name of the appellant was not recommended by DSP, though two persons who were below in merit, namely Tokheswar Patil and Ranu Sahu, were recommended. They had obtained 59th and 60th position respectively in the merit list. The appellant felt aggrieved thereby and made a representation to the effect. However, her representation did not elicit the positive response even when it was followed by a reminder dated 25/5/2007. This apathy of the respondent forced the appellant to approach the High Court in the form of writ petition filed under
Yes, continue.
Then paragraph 7, she approached the appellant challenged the aforesaid order of the learned single judge by filing writ appeal. In the writ appeal, she did not pursue her case of age relaxation up to 8 years on the ground that she was a government servant. Instead, she relied upon Rule 4 of 97 rules, wherein relaxation of 10 years is available to women candidates in addition to other relaxation in age. The division bench has held that benefit of Rule 4 of 97 rules shall not inure to her benefit, and the entire discussion in support of this conclusion is contained in paragraph 52 and 53 of the impugned judgment, which are reproduced hereunder. We are unable to accept this argument. The advertisement clearly mentioned that for the post DSP, minimum and maximum age limit would be 22 and 25 years, clearly spelling out the terms and conditions for relaxation of age criteria. From bare reading of Rule 8 of 2000 rules, it is clear that age relaxation under the 1997 rules is not applicable for recruitment on the post of DSP. From the advertisement also, it is evident that no relaxation in age of recruitment for the post of DSP was available to the women candidate, whereas age relaxation under the aforesaid rules have been made applicable to in other categories. Since there was no challenge by the appellant to the applicability of rule of the 2000 rules, she cannot be permitted to assail the impugned judgment on the ground that she was entitled for age relaxation as provided under Rule 4 of the 1997 rules. As is clear from the aforesaid reason given by the High Court, Rule 8 of the 2008 rules would prevail upon the 1997 rules, and therefore the 97 rules are not applicable for recruitment to the post of DSP. The High Court has also persuaded by the stipulation contained in the advertisement, as per which outer age limit for the post of DSP was 25. The whole controversy therefore revolved around interplay of the 97 rules and the 2000 rules as well as other rules. That was precisely the focus of argument of the learned counsel for the parties. Now the decision of the apex court, it is clear, the 2000 rule directly says 97 rule is not applicable, although for the post of DSP. Then also the court has interpreted the provisions of 97 rules with the objective sought to be achieved. By what objective? Though it has been said to be not applicable, but what objective it has by this rule sought to achieve? So that objective court has gone into and it said that it has an universal application. So therefore, this benefit which has been made to women has to be given. This paragraph 24, in the In the first instance, it is to be borne in mind that the 97 rules are specific rules specifically meant to give benefit of age relaxation to women in public service and on post in connection with the affairs of the state. These rules are statutory in nature, framed under the proviso to Article 309 of Constitution of India. Such a special provision is made in favor of female in consonance with the constitutional spirit contained in Article 15(3) of the Constitution of India, which empowers the state to make any special provision for women and children. The salutary purpose and objective behind promulgation of 1997 rules is manifest and can be clearly discerned. It is to encourage women, a hitherto known as weaker section, to become working women by taking up different vocations, including public employment. It would naturally lead to empowerment of women, which is the need of the hour. Women in the world and particularly in India, this all the needs why the particular act has been, rule has been created. So this has been discussed, my lord. Then comes to 29, keeping all these objectives, my lord. Paragraph 29, I'm just trying to make it short, my lord. Otherwise this 24, 25, 26 and 28, these are relevant. 29 is the, my lord, keeping in view all the aforesaid and other relevant consideration. When such affirmative actions are taken by lawmakers in the form of subordinate legislation, they need to be enforced appropriately so that purpose that is intended is suitably achieved. Seen in the context of Rule 4 of the 97 rule is to be interpreted to have universal application when it comes to women candidate seeking appointment in public service and post in connection with the affairs of the state of Chhattisgarh. After all, that is the primary purpose behind enacting the aforesaid rules having statutory character. Though 2000 rule excludes the application of 97 rules, the Supreme Court has said no. It has an universal application taking note of the objective for which the rule has been created, that is to empowerment of the women at different angle. This has been discussed, so therefore the court has said that this is applicable and she has been granted the relaxation of age. Now in our context, Your Lordship, my lord, though there is no ambiguity in the rules, then also, my lord, the legislative intent of incorporating this Rule 5 is clearly for the upliftment of these disadvantageous classes of people. So that objective has to be, my lord, kept in mind. And my lord, these objectives, Lordship may find, my lord, in the case of State of UP versus Dinanath Shukla, 1997, 9 SCC 662.
1997,
9 SCC 662. I'm just giving the what is the objective of this, my lord, reservation, my lord. So for scheduled castes and scheduled tribes are concerned. Only two paragraphs I will read, my lord. Para 6 and 7. Paragraph 6. Article 46 of the Constitution enjoins that educational economic interest of the Dalits, tribes and other backward sections shall be promoted by the state with special care of the Dalits and tribes. They shall be protected from social injustice and all form of exploitation. Article 38 envisages that the state shall strive to promote welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economical and political shall inform all the institutions of the national life, in particular to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals but also amongst group of people residing in different areas or engages in different vocations. The preamble of the Constitution, which derives sources of power from we the people of India, that is Bharat, and visions an egalitarian social order to integrate all the people with equality of status, dignity of persons, and fraternity as a united Bharat, and providing them socio-economic justice, equality of opportunities, and status and dignity of person. It is subtle legal position that the preamble is a part of the Constitution and is the basic structure of the Constitution. Every citizen is born equal but gets chained within impregnable walls of social, sectional, and religious barrier and is made a victim of discrimination and denuded of human rights. Article 14, 51, and 16(1) banish all barrier of discrimination on the ground of religion, race, sex, caste, place of birth, any of them. That paragraph 7, when there is a clash of interest and competition claim, there is craving of equality of opportunity among the people and for emancipation from the pangs of absolute prohibition. Article 14, 15, 2 to 4, 16, 4 and 4a, read with directive principle, poured forth practice content, softened the rigors of legal equality and gave practical content of equality in opportunity, resulting though distributive justice in favor of unequals to hold an office or post under the state in the democratic governance. These articles give power to the state to make positive discrimination in favor of the disadvantaged, in particular the Dalits and tribes. Socio-economic empowerment secure them dignity of persons and equality of status. Appointment to an office or post gives opportunity to have equality of status and dignity of persons. The object thereby is to provide socio-economic equality. Social equality gets realized through facilities and opportunities given to them to live with dignity and equal status in the society. Economic equality also gives social economic empowerment as a measure to improve excellence in every walk of life. Article 15A(h) enjoins on every citizen to develop scientific temper, humanism, and spirit of inquiry and reforms, and charges the citizens to promote harmony, spirit of common brotherhood, transcending all social, religious, regional, and linguistic barriers. Article 15(1)(a)(j) enjoins the citizen to strive towards excellence in all spheres of individual and collective activities so that nation constantly rise to higher level of endeavor and achievement. Equal opportunity of appointment to a post office is available to all citizens and legitimately and constitutionally entitle them to consider their claims for employment, appointment to an office or post. There are many aspirants for a few post offices which generate spirit of competition. Article 335 mandates the state that in the field of competition the claim of Dalit and tribes shall have to taken into consideration consistently with the maintenance of efficiency of administration in making the appointment to service and post in connection with the affairs of the Union of India. Now, my lord, this has been said, my lord, efficiency of administration in making the appointment, the efficiency is not to be, my lord, compromised. That was one of the angle, my lord. On the same line, my lord, this Thomas case, my lord, AR 1976 Supreme Court, my lord, 1996 2 SCC 310, 1976 2 SCC 310. Well, I'll not read out the thing, but I'll just give the paragraph. These are the same things with regard to the, my lord, objective of Article 14, 15, 16, and 335 of the Constitution of India. How these have been incorporated in the Constitution, how it has come, how it tried to, my lord, remove the disequalities among the different, my lord, sect of people, more particularly, my lord, scheduled tribes.
What are the relevant paras?
My lord, relevant paras, my lord, 21, 28, 29, 30, 31, 37, 40, 43, 44 and 45. Now, the second aspect of the matter, whether this age election is actually compromised with the merit or the efficiency or the, my lord, the administrative quality, my lord. My lord, this has been, my lord, discussed in the case of my lord Jitendra Kumar Singh, my lord, as 2010 3 SCC 119. I'm just referring to one or two paragraphs in this. Paragraph 43. Paragraph 43.
Yes.
Yes. It is in this context we have to examine the issue as to whether the relaxation in fee and upper age limit of 5 years in the category of OBC candidate would fall within the definition of reservation to exclude the candidate from open competition on the seats meant for the gathering general category candidate. Taking note of these submissions, the division bench has concluded by considering the question number 1, 2, and 3 that concession in respect of age, fee, etc. are provisions pertaining to eligibility of a candidate to find out as to whether he can appear in the competitive test or not, and by itself do not provide any indicia of open competition. According to the division bench, the competition would start only at the stage when all the person who fulfills the requisite eligibility conditions, namely qualification, age, etc., are shortlisted. We are of the opinion that the conclusion reached by the division bench on the issue of concession and relaxation cannot be said to be erroneous. Then 48, my lord.
48.
Fourth line, my lord, from top, my lord, paragraph 48.
Yes.
It is to be noticed that reserve category candidates have not been given any advantage in the selection process. All the candidates had to appear in the same written test and face same interview. It is therefore quite apparent that the concession in fee and age relaxation only enables certain candidates belonging to the reserve category to fall within the zone of consideration. The concession in age do not in any manner tilt the balance in favor of the reserve category candidate in preparation of the final merit select list. Then, the paragraph 49 as well, fifth line, such as concession and relaxation in fee of age providing to the reserve category candidate to enable them to complete and seek benefit of reservation is merely an aid to reservation. The concession and relaxation place the candidate at par with general category candidate. It is only thereafter the merit of the candidate is to be determined without any further concession in favor of the reserve category candidate. So, my lord, my argument, my lord, has, my lord, so far as the interpretation is concerned, my lord, without taking note of any of the judgment, any of the external aid, the literal interpretation, then objective of the rule, my lord. And now, even if a doubt arises whether the NIT really has the power to do it, though it is mentioned, whether it really has a power to do it. Now, my lord, that has been, my lord, decided, my lord, that's the theory of implied power, my lord. In a case, my lord, this Sikiri Basu versus State of UP, 2008 2 SCC. It is clear two provisions are there that the authority has the power. But in what manner, if at all doubt arises, my submission is that there is absolutely no, even then also, the implied power is inherent on the authority because they have the power to do to give the concession. The paragraph I am referring to, my lord.
Page number.
This is 2008 volume 2 SCC 409. I am referring to paragraph 18.
Yes.
It is a well settled that when a power is given to any authority to do something, it includes such incidental or implied power which would ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, there is impliedly include the grant even without special mention, every power and every control and denial of which would render the grant itself ineffective. Thus, where the act confers jurisdiction, it impliedly also grant the power of doing all such act or employ such means as are essential necessary for its execution.
This was in context of which,
My lord, though it has not been, my lord, directly raised that there was a select list, there was a list of eligible candidates at the first instance. Though subsequent, my lord, this, my lord, publication of the second list has not been mentioned, but there may be raised whether they have the power to do that, my lord. So when they have a power to select, that power also includes to correct. If the fault is somewhere, my lord, it can be corrected, number one. And secondly, if the rule, though it, my lord, Rule 5 as well as the, my lord, this annexure clearly provides that both are different category and different, my lord, the concession has been given. And whether to give or not, that will be on the authority. And they have employed it with the objective for which the Rule 5 has been incorporated. So this power is implied on them. And the authority has done, my lord, the presumption is always that they have done in a, my lord, as per the, my lord, law, my lord, in good faith. And there is no allegation of malafide, there is no allegation of, my lord, any foul practice by either of the respondent number 5 or by the NIT. My lord, these are the, my lord, the judgments, my lord, which I have referred to. Yesterday, another notification was placed to contain that notification bars. I exactly did not get in, but if that be the 17 of dated 17/1998.
yes.
Is it, if it is available with your lordship, then it is the same one. It is dated 17/1998. Yes, my lord. This is altogether for a different purpose. Lordship will kindly see the paragraph 2, my lord. I will read from the top, my lord. The undersigned is directed to refer to this department's number so-and-so dated May 1989 and to clarify that the instructions contained in the OM apply in all type of direct recruitment, whether by written test alone or written test followed by interview or by interview alone. OM dated May 22, 1989 referred to above and the OM number so-and-so dated July 2nd, 1997, provide that the case of direct recruitment, the SC, ST, OBC candidate who are selected on their own merit will not be adjusted against reserved vacancy. Those are on those lines, my lord, nothing to do with our case, my lord. Now it is well settled, if the rule provides that they can migrate, then they will migrate. If the rule doesn't provide, they will not migrate. So that is, it has no application so far as the present case is concerned, my lord. That paragraph 3, in the connection it is clarified that only such ST, SC, OBC candidate who are selected on the same standard as applied to general candidates shall not be adjusted against reserved vacancies. In other words, when a relaxed standard is applied in the selecting an ST, SC, OBC candidate, for example, in the age limit, experience qualification, permitting number of chances in written examination, extended zone of consideration larger than what is provided for general category, etc., the Supreme Court, the SC, ST, OBC candidate are to be counted against reserved vacancies. Such candidate would be deemed unavailable for consideration against unreserved vacancy. Well, it has nothing to do, my lord, with our case, my lord. It is only with regard to the migration when there is, my lord, both posts are, my lord, sought to be filled up by direct recruitment. And apart from that, my lord, from his, my lord, these documents, these office memorandums are not suo motu applicable to any of the department. And this has not been, my lord, Lordship has seen the rule, my lord, this has not adopted by the NIT. They have adopted the reserve category so far as age relaxation is concerned. That has been, my lord, adopted. But so far as migration, etc., this is nothing to do with the, my lord, the rules of 2019. Now, finally, my lord, the selection was initiated in 2012. And, my lord, first of all, my lord, in the writ petition, he did not, my lord, mention about the second selection, that second list. He did not challenge that eligibility list that was published on 4/1, which is available, my lord, at page 41 of the affidavit in reposition submitted by the respondent number 1 to 4, my lord. This is not under challenge. Then, thereafter the written examination was, he has allowed the, my lord, he himself has participated in the, my lord, the selection process. He appeared, because written examination was held on 21/1/2023. He appeared, then having failed or having secured second, he started looking for the fault of the, my lord, any fault is there in the appointment of the petitioner.
What is the date of the second list?
It is 4/1/2023.
And the exams held on?
21/1/2023.
Okay.
Result was published on 24/1/2023. This is available at serial number, page number 96 of affidavit in opposition filed by the respondent number 5.
Result given
Result
on?
declared on 24/1/2023. It is available at page number 96 of the affidavit in opposition filed by respondent number 5. Then, my lord, the selection was made. Offer letter was issued on 22/2/2023. And appointment was made on 7/3/2023. All these documents are available with the affidavit in opposition of the respondent of 5, my lord. Now he waited, my lord, till the collection of the documents, my lord, and he filed the writ petition in the month of July. By that time, I have left my job. There is no fault on my part at all. There is no allegation Not only against me, not against the, my lord, NIT as well. If at all, my lord, for any reason, my lord, if at all found that the selection and appointment of the respondent number 5 was illegal, what would be the consequences, my lord? It's a court of equity. Balance has to be stricken, my lord, to the both sides, my lord. I have left a job purely on bona fide, purely on selection on merit. I have secured highest mark. There is no challenge to that. There is no compromise with the merit. That post has been filled up. 2 years gone by. I have changed my status, everything. Then equity would demand definitely to seek the compensation by way of damage from the NIT by the writ petitioner. Because for no fault of mine, I have joined there. Apparently, there is no allegation against the NIT. Then also, well, for any reason, it has been found. Whereas he is working as a, my lord, in a central government organization. My position will be, my lord, in the, if your lordship looks into the, my lord, in the angle of the equity, my lord. May not like to interfere with the appointment of the, my lord, present petitioner. He may seek his redress, if at all, but the conduct what has appearing in the, my lord, writ petition, approaching at a delayed time, participating in the process selection, then waited till the selection, whether he gets selected or not, then having not selected, trying to look for some document here and there and filing the writ petition, suppressing the fact that there was a second selection list, there was a committee which has approved the second selection list. That's all, my lord. That's my submission.
So second half, I think the NIT council will be submitting. Mr. Zoram Chana. Then a
But
reply.
Can it be on day after tomorrow, my lord? In case I cannot come, my lord, in that case, my lord, my friend will be there, my lord, because
No. Why day after tomorrow?
My lord, if I may, your lordship,
You have completed your submission. What else do you want to submit? The second half, we'll hear the NIT council. Then we'll have a reply from him. Then matters end there.
matters also. That is there.
All
Then
right.
I may be permitted to leave, my lord.
Sure,
lordship.
sure.
Second half, I will not be here.
Yes.
그게 후아테 affidavit 그게 옴. Isso é Dang.
I'd like to point some papers wherein, my lord, the NIT has relied on, my lord, regarding that inclusion of the respondent number 5 herein, lordship.
You are for respondent number 1 to 4.
Number 1 to 4, lordship.
1 to 4.
1 to 4. As was earlier submitted, my lord, page number 201 of the petition, my lord, is the advertisement, my lord. Advertisement floated by the NIT Mizoram, my lord, wherein at serial number 2, my lord, Superintendent Group B, 1 post unreserved, pay level 6, was also one of the advertised vacant posts, my lord, for which, my lord, this advertisement was floated, and then in response of which, my lord, initially there are 146 eligible candidates, which is published by the NIT, my lord. If I may take your lordship to affidavit filed by NIT.
By the way, how many departmental candidates have participated?
That, my lord, I'm sorry, my lord, I do not.
Petition is, no, the private respondent is 1.
1, yes, my lord.
And there's another person whose name was pointed out, isn't it? Who was rejected earlier also?
Yes, that is there in the list too, my lord.
Due to overage?
Due to overage,
And
and after reconsideration, my lord.
Is he also a departmental candidate?
My lord.
Okay.
So
Okay, you may go.
now
I'll call you.
after the respondent number 5, my lord, filed this request for reconsidering his application for the post, my lord, which is found at page 17 of my affidavit, my lord. I think your lordship had already gone through, my lord. This is a request for reconsideration of my application for a post of superintendent at NIT Mizoram, my lord. Herein,
Page 17.
17, yes, your lordship, of my affidavit. I'll go straight to second paragraph, your lordship.
Yes.
The only probable reason for rejection of my candidature might be on the ground of being overage. If this is the case, I earnestly request you to please revisit my application referring to the DOPT order on information document on grant of relaxation of upper age limit, point number 5.2, Annex 1, which states that age concession of 5 years are allowed to departmental candidates, central government employees in case of recruitment to Group A and Group B posts, which are filled through UPSC, other than those filled on the basis of competitive examination, and posts which are exempted from the purview of UPSC, where recruitment is made by organizations themselves. This concession is admissible to such of the government servants as are working in posts which are in the same line or allied cadres, and where a relationship could be established that the service already rendered in a particular post will be useful for the efficient discharge of the duties of posts. And to clarify this, my lord, he has also enclosed documents at page 18, the next page, my lord. And these are compilations of relevant instructions. And these instructions, my lord, are based on the notifications earlier issued by the concerned Government of India, lordship. If I may take your lordship to page 27, my lord. 27. This is OM, Office Memorandum dated 24th of October 1985, your lordship. If I may read, lordship.
Yes.
Subject is relaxation of upper age limit for departmental candidate for appointment to Group A and B posts in their own department. The undersigned is directed to say that as per these departmentals OM number so-and-so dated 20 July 76, the age relaxation up to 35 years in favor of in favor of departmental candidates for direct recruitment in Group C and D will be available for a post under the control of the same ministry department. On a review of the above mentioned instruction, it is observed that the requirement of there being a nexus between the duties of the post to which recruitment is being made and those of the post held by the departmental candidate for availing of the age concession is met even if not the earlier service was under some other ministry department, as the duties of common post clerk are the same. By and large, in all the ministries department, this restriction of consideration of the departmental related to the vacancies under the same department seems to be unnecessary. Accordingly, it has been decided that the words and the age relaxation will be available for the posts under the control of the same department. That has to be deleted, and so the rest of the OM remains the same. So to clarify that, my lord, there is another 87 notification official memorandum at page 29, my lord. Page 29, my lord. This is office memorandum dated 15th of October 1987, your lordship. The undersigned is directed to invite attention to these departments OM so dated 9 April 1991, according to which government servants may be allowed relaxation up to the maximum of 5 years in the upper age limit for recruitment to Group A and B posts, which are filled through the Union Public Service Commission other than those filled on the basis of competitive examinations. This concession is admissible to such of the government servants as are working in posts which are in the same line or allied cadres, and where a relationship could be established that the service already rendered in a particular post will be used for the efficient discharge of the duties of the post, recruitment to which has been advertised as per the above mentioned OM. Decision in this regard rests with the Commission. It was not, however, made clear in the above instructions that this concession is available to departmental candidates for recruitment to Group A and B posts which are exempted from purview of UPSC, and therefore recruitment to which is made by the organization themselves. For example, Group A and B posts in paramilitary forces, scientific, technical posts in scientific department fall in the category. As it was not intention to deny this concession in the cases of this type, it is hereby clarified that the provision of the above mentioned OM are also applicable to departmental candidates for Group A and B posts to which recruitment is made by the body other than UPSC. So now we are not UPSC, my lord, but by virtue of this notification, my lord, we as an independent body, my lord, can now rely on this for giving concession to the relaxation to the respondent number 5. And now if I may take your lordship now, this is regarding departmental candidates will have to be relaxed by 5 years. Lordship. Accordingly, he was given relaxation of 5 years. And now regarding the scheduled caste and scheduled tribe relaxation, my lord. If I may take lordship to page number 31, my lord, of my affidavit. Same affidavit. This is notification 7 March, my lord, 1974. Here it specifically and clearly stated that, my lord.
Yes.
Yes, your lordship. If I may read, lordship. Certain age concessions have in the past been sanctioned to a few specified categories of persons for the purpose of appointment under the government of India. These concessions are still in force until further orders. Details of the categories of persons and age concessions admissible to them are given below, are hereby published for general information. Then categories, small Roman, scheduled tribes and scheduled castes, lordship. Number, and then on the same row, my lord, at the last column, my lord. Extent of age concession, 5 years. So now, my lord, based on these two notifications, and on revisiting the application, the representation submitted by the respondent number 5, the authority, competent authority in the NIT, my lord, made a conscious decision in issuing the notification dated 4th of January 2023, which is found, my Lord, at page 41 of my affidavit, Lordship. 41, my Lord. And now in supersession of that earlier list, my Lord, which was issued earlier, my Lord, this second list had been issued by the authority, my Lord, in the NIT. And now at serial number 147 and 148, my Lord, 2 candidates, including the respondent number 5, my Lord, have now been included herein, my Lord. 147, we found the respondent number 5 herein, Larino Makiante, and another one also, Mr. Kaliandas also was included afresh, my Lord. So this, my Lord, this fresh inclusion, the fresh notification dated 4th January of 2023, my Lord, has till now, if I'm not mistaken, my Lord, been challenged, my Lord. This has attained finality, my Lord. Even now, my Lord, the prayer of the petitioner has today been granted, my Lord. It will be futile, my Lord, unless this is set aside, challenged and set aside, my Lord. As the Lordship knows well, that there are catena of judgment, my Lord, on this point. And for that, my Lord, examination was held and at page 49, my Lord. Page 49 of my affidavit. This is the result of mock evaluation for the competitive written exam for the post of superintendent, my Lord. This list is prepared in order of merit, my Lord. In order of merit. So at serial number 1, we find the respondent number 5 as being the first rankers, my Lord. He is the topper of the examination. He secured the highest mark. That, my Lord, is why he has been selected. And the selection committee in their meeting held on 14th of February 23, my Lord, recommended the respondent number 5 for appointment to the post of Superintendent Group B, my Lord. And minutes of the meeting is at page 51 of my affidavit, Lords. 51 of my affidavit. And thereafter, at page 53, my Lord, 53, offer of appointment was there, my Lord. Offer of appointment was there at 53. And accordingly, order of appointment at 55, my Lord, page 55. So now, my Lord, there is nothing in the petition which challenges the proceedings, the procedure taken by the NIT, answering NIT in this making the decision, my Lord. So that is not challenge till now. And now this decision itself, to my humble knowledge, my Lord, still stands. So there is nothing wrong, my Lord, in the process how the respondent number 5 has been selected, my Lord. It's duly done, my Lord. That is my submission, Lord.
So, my Lord, my understanding of the submissions my lord, with respect to their first submission, my lord, from both of them, my lord. As I can understand is, my lord, their submission is that we did not challenge the decision-making process, my lord. Now, in this respect, my lord, let me quickly take your lordship back to their affidavit, my lord, which my learned friend had just taken your lordship to. Now,
Affidavit of,
of the state of the respondent numbers 1 to 4, my lord.
okay.
Now, at page 17, my lord, this was the representation that he had submitted. Now, in this representation, your lordship will see there is no mention of the notification which my learned friend had read. My lord, that notification at page number 27 to page number 29. He had mentioned only 2 notifications, my lord, which are at page number 18, page number, sorry, to be precise, page number 20. Page number 20, 5.2. 5.2, that is the only notification, my lord, he had mentioned in the representation.
Yes.
Thereafter, my lord, what they have stated in their affidavit, this runs counter to the representation that was submitted at page number 4, my lord. Roman number 2. My lord, I'll read from 2. Thereafter, the screening committee, my lord, conducted the screening, and out of 283 candidates, applicants, 146 eligible candidates were selected for the competitive written examination, direct recruitment for the post of Superintendent Group B, wide notification, so and so. Whereas the petitioner was included among the eligible candidates, the respondent number 5 was excluded on the ground that he had already crossed 30 years of age on 3/8/2022. That is the last date of submission of application. However, the respondent number 5, being aggrieved, had submitted a representation dated 23/12/2022 by referring to the DOPT memorandum dated so and so. This is the memorandum I had shown your lordship, which is at page number 20. And also the other one, which is of dated 15/10/1987. This is also at page 20. By which age concession of 5 years are allowed to departmental candidates, central government employees in case of the posts which are exempted from the purview of UPSC. Besides this, my lord, he referred to another DOPT notification. This was absent in the representation. Dated 7/3/1974, allowed age concession of 5 years for the scheduled castes and scheduled tribes for the purpose of appointment under the government of India in respect of all posts filled by direct recruitment. Therefore, the claim of the respondent number 5 by way of his representation is that he could avail age concession of 5 years as his departmental candidate and also another 5 years age concession as he is the scheduled tribe. My lord, this was never claimed by him in his representation, my lord. Your lordship will come back to the representation. He had simply claimed for 5 years. And thereafter, at serial number 3, my lord, they had mentioned like this. After his representation was considered by the screening committee, NIT Mizoram, and found to be correct and reasonable, the respondent number 5 was found eligible to apply for the post of Superintendent Group B, along with the respondent number 5. One of the applicants, namely Sri Kalyan Das, whose application was earlier rejected on similar ground, was also found eligible. The minutes of the screening committee dated nil, my lord, this meeting minute they have mentioned, for the post of Superintendent Group B substantiated this fact. Now, this meeting minute, my lord, is enclosed by them at page number 35. Now, this meeting minute, my lord, is from page number 35. In my petition, it's from page number 35 to page number 40. It ends at page number 40. Now, Your Lordship will kindly turn to page number 40. Now, my Lord, if Your Lordship will see, the last name is Benjamin Lalrin Omar. Now, this meeting, so-called meeting minute, my Lord, first of all, does not have any reason mentioned, and the name of the respondent number 5 is not reflected in this meeting minute. This is one thing that I would like to point out to Your Lordship, my Lord. So that reason is not there only for accepting that representation in the first place, and secondly, in this meeting minute, my Lord, his name is not there. And if Your Lordship will come thereafter, my Lord, in their affidavit, they have mentioned something completely different from the actual records, my Lord. We have, that is basically the records.
There's page 35.
Yes.
This is after the rectification or prior to rectification?
No, so as per there, my Lord will come back. If Your Lordship will see page 6. Okay, Lordship will see page 5. Number 3, serial number 3, my Lord. After his representation was considered by the screening committee of NIT Mizoram and found to be correct and reasonable, the respondent number 5 was found eligible to apply for the post of Superintendent Group B, along with respondent number 5. One of the applicants named is Sri Kalyan Das, whose application was earlier rejected on similar ground, was also found eligible. The meeting, my Lord, after the representation, they said he was found eligible, my Lord, and then thereafter they said the meeting of the screening committee dated nil for the post of Superintendent Group B substantiated this fact. Now that meeting minute at page number 35, my Lord, that is post the representation, post the acceptance. In fact, my Lord, this is my humble understanding. This meeting minute is the only material produced, my Lord, by them to show the decision process. And this is at page number 35. It talks of the list of eligible candidates, my Lord. And it goes on till page number 40. And Your Lordship will see that the names of those two people are not yet reflected. And not just that, my Lord, this meeting minute has not provided any reason, my Lord. And I will take Your Lordship to a Supreme Court judgment, my Lord, which says that whenever you are going to relax, my Lord, there has to be a proper reason. This meeting minute contains no reason, my Lord. It's unreasoned. And subsequently, the notification dated 4 January 2023 was issued, which also does not provide any reason. And on top of that, my Lord, the submission of the senior advocate, my Lord, was that this 4 January 2023 was not published. It was never published. And the only justification they have given, my Lord, is in their affidavit. The affidavit is the only time, my Lord, they have provided any reason for applying that ST quota, ST concession, my Lord. It was never mentioned in the representation. It was never mentioned in the meeting minute, nor in that notification which was not published. And in this respect, my Lord, I would like to cite, my Lord, a Supreme Court judgment. This was reported in 2018-8 SCC 141, my Lord. 2018-8.
18-8.
SCC 141.
Paragraph?
My Lord, paragraph 11. Paragraph 11, my Lord. The learned counsel for the petitioner has thus rightly drawn our attention to the Constitution Bench judgment of this court in Mohinder Singh Gill versus Chief Election Commissioner to submit that such a plea cannot be accepted. We may note that this is a well-settled legal position in many judicial pronouncements of this court, but it is not necessary to revert to the same. In para 8 of the said judgment, V.R. Krishna IRJ in his inimitable style stated as under. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned. My Lord, it has to be judged by the reason in that meeting minute alone. and cannot be supplemented by fresh reasons in the shape of affidavits or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to our court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Bose J. in Gorjandas Bhanjan, my lord. Next page. Public order, publicly made in exercise of a statutory authority, cannot be construed in light of explanations subsequently given by the officer making the order, of which he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to effect the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. And finally it says like this, my lord, orders are not like old wine, becoming better as they grow older, my lord. Now in our case, my lord, this is a classic case where an order, a meeting minute, has been made to look like an old wine, my lord. And secondly, my lord, I would also like to cite this judgment. This is a judgment of the Supreme Court reported in 1997. My lord, I'll provide judgment to you. My lord, 1997, 6 SCC 614, my lord. And the relevant portion is at paragraph number 11, my lord, page number 620. Paragraph 11, my lord. In our view, this kind of an interpretation cannot be given to a rule for relaxation of age. The power of relaxation is required to be exercised in public interest in a given case. As for example, if another suitable candidates are not available for the post and the only candidate who is suitable has crossed the maximum age limit, or mitigate hardship in a given case, such a relaxation in special circumstances of a given case is to be exercised by the administration after referring the case to the Rajasthan Public Service Commission. There cannot be any wholesale relaxation, so on and so forth, my lord. My humble submission, my lord, is there has to be reason, my lord, that shows that the relaxation is exercised in public interest. And my lord, will come to the next page. This kind, I'll start from the bottom. The kind of power of wholesale relaxation would make for total uncertainty in determining the maximum age of a candidate. My lord, this is very, very relevant, my lord. It might be unfair to a large number of candidates who might be similarly situated, but who may not apply, thinking they are age barred. We fail to see how the power of relaxation can be exercised in the manner contended.
Yes.
So, my lord, that reason has to be there, my lord, which is absent in our case. Now, finally, my lord, I would like to cite in this respect one more Supreme Court judgment which is reported in 2010, my lord, volume 7. 2010, volume 7, page number, my lord, I'll give you a page number 678.
SCC, isn't it?
My lord, SCC, 2010, 7 SCC 678. My lord, relevant portion starts from paragraph number 24. I'll read paragraph number 24, my lord, and my lord, 687. I'll read paragraph number 24, my lord, and I'll also read paragraph number 30, my lord. In the instant case, the order passed by the competent authority does not state any reasons whatsoever for the cancellation of the typing test. It is nobody's case that any such reasons were set out even in any contemporaneous record or file, my lord. The same thing with us. In the files that they have submitted, my lord, no reason has been given. In the absence of reasons in support of the order, my lord, the final order needs to be supported by reasons before. It is difficult to assume that the authority had properly applied its mind before passing the order cancelling the test. Now finally, my lord, at paragraph number 30. We may hasten to add that while application of mind to the material available to the competent authority is an essential prerequisite for the making of a valid order, that requirement should not be confused with sufficiency of such material to support any such order. Whether or not the material placed before the competent authority was in the instant case sufficient to justify the decision taken by it, it is not in issue before us. That aspect may have assumed importance only if the competent authority was shown to have applied its mind to whatever material was available to it before cancelling the examination. Such application of mind as a threshold requirement for a valid order is conspicuous by its absence. My lord, the same with us. The question whether the decision was reasonable, having regard to the material before the authority, is rendered academic. So, my lord, the entire process, my lord, is rendered academic. Sufficiency or otherwise of the material, and so also its admissibility to support a decision, the validity whereof is being judicially reviewed, may even otherwise depend upon the facts and circumstances of each case. No hard and fast rule can be formulated in that regard, nor do we propose to do so in this case. So, my lord, my humble submission, my lord, by relying on this judgment, is that entire process they are saying, my lord, we have not challenged. That entire exercise, my lord, would become academic anyway, my lord, because there was no reason given by them. And the order, the final order that we have challenged, my lord, would have no legs to stand on. So that is, my lord, my rebuttal with respect to the first one, my lord. And now, my lord, the other one that they have cited was with respect to the non-obstante clause, my lord. This learned senior had cited a Supreme Court judgment on non-obstante clause. Now, my lord, in this respect, my humble submission is this, my lord. Section 5, rule number 5 starts with nothing in these rules, my lord. Now, when there is a provision like this, my lord, this is what I have found out, my lord, and I'm citing a Supreme Court judgment, my lord, which is reported in 1992, 1 SCC 335. My lord, this kind of non-obstante clause becomes relevant when there is a general rule and when there is a specific rule, my lord. In our case, my lord, this is my humble understanding that the NIT rules which we have cited, my lord, that is the special rule, and the entire Government of India regulations which they have cited, my lord, the office memorandums, they are general rules. And, my lord, I will take your lordship to page number 340, my lord, at paragraph number 6. Now, my lord, I'll read out the facts, small facts, my lord. We shall now refer to the relevant special and general rules. So, in their case also they have special and general rules. The special rules were framed in exercise of the powers conferred by the proviso to Article 309 of the Constitution of India in the year 1976. The special rules of recruitment for the category of post of Deputy Commissioner of Transport reads thus. So this is the rule. And finally, my lord, it can be seen that this part of special rules clearly provides for promotion to the post of Deputy Commissioner of Transport by selection from the cadre of regional transport officers who have put in not less than 5 years of service. Then thereafter, my lord, they have the general rule. The general rules were framed in the year 1977, and Rule 3 reads as under. So, my lord, Rule 3 is analyzed, but if your lordship will come to the next, my lord, it paraphrases Rule 3. C, my lord, it may be noted that Rule 3.2, which we are concerned mainly which we are mainly concerned, was inserted in the year 1982. Sri Chidambaram strongly relying on the non-abstante clause in Rule 3.2, with which this sub-rule begins, contended that this general rule clearly supersedes the special law, and therefore, according to him, the tribunal was right in holding that the promotion to the post of Deputy Commissioner of Transport could be only on basis of seniority cum merit. And my lord will come to page number 343, my lord. There the discussion begins regarding non-abstante clause. My lord will see there is in the first paragraph, in lines with that C, starts like this. The non-abstante clause, my lord has seen it. The non-abstante clause
Yes.
is sometimes appended to a section or a rule in the beginning with a view to give the enacting part of that section or rule in case of conflict. My lord, so non-abstante clause only comes into operation when there is conflict. In case of conflict, an overriding effect over the provisions or act mentioned in that clause. Such a clause is usually used in the provision to indicate that the said provision should prevail, despite anything to the contrary in the provision mentioned in the non-abstante clause. And then it goes down, my lord, and I'll take your lordship now, my lord, to page number 438, my lord. Paragraph number 13. As already noted, there should be a clear inconsistency between the two enactments before giving an overriding effect to the non-abstante clause. But when the scope of the provisions of an earlier enactment is clear, the same cannot be cut down by resort to non-abstante clause. And my lord, if your lordship will go down, your lordship will see there is a line which starts in the given case. My lord has seen it below.
You're reading from which page?
My lord, page number 348. My lord will see paragraph number 13 towards the end of the first paragraph number 13.
You said 438, that's why I was turning 438.
Oh, my lord, I'm sorry.
348.
348, my lord.
Under paragraph number?
It starts
13.
with paragraph number 13.
Yes.
I'll read the first 4 lines first, my lord. As already noted, there should be a clear inconsistency between the two enactments before giving an overriding effect to the non-abstante clause. But when the scope of the provisions of an earlier enactment is clear, the same cannot be cut down by resort to non-abstante clause. And my lord will go down, your lordship will see beside E in the same paragraph, the amendment.
Yes.
And below that amendment, there's another line, my lord. This line is significant. In a given case where there are no special rules, then naturally the general rule would be applicable. My lord, that in essence, my lord, that highlights what a non-abstante clause is, my lord. So in essence, my lord, what it's saying is when there is a general rule and a special rule, and there is a contradiction, then the non-abstante clause will come into operation. And this line gives it very clear. In a given case where there are no special rules, then naturally the general rule would be applicable. In our case, my lord, until and unless there is a specific rule, my lord, which in our case is with respect to the superintendent, the provision relating to superintendent, this non-abstante clause under section 5, my lord, would not operate simply because they do not conflict. And once, my lord, let's say, for instance, once that field has been taken off, that special enactment has been taken off, then in that case, my lord, the general rule would come back into operation. In other words, my lord, what I'm trying to say is non-abstante clause does not give cumulative benefit, my lord. It gives alternative benefits. And my lord, there are many provisions which has a clause called, my lord, there is one non-abstante clause.
Yes.
Yes, there are some provisions, my lord, where you have, let's say, non-abstenter clause, my lord. This is a case where we have the non-abstenter clause. Similarly, my lord, there are cases where you have in addition to clauses, my lord. This is, so non-abstenter clause cannot be read as a provision which is in addition to clause, my lord. For instance, in the Mizoram Marriage and Inheritance and Property Act, my lord, there is one section, my lord, which I have brought, section number 39. My lord, there it clearly says like this: save as otherwise provided, the provisions of this act shall be in addition, my lord, to and not in derogation of any other law for the time being in force. So, my lord, my humble submission is this, my lord: the abstenter clause that we have mentioned at paragraph number 5, section rule 5, would come into operation only if there is an inherent conflict between the special and the general law. In our case, there is no conflict. The first conflict that could have arisen, my lord, is, let's say, in our provision it says you can have 5 years of SC/ST, and the general law says you can have 10 years SC/ST. Then, my lord, there would be a conflict. Then in that case, the non-abstenter clause would come into operation. But if there is no conflict, my lord, what it says is the special law will operate, and when the special law ceases to operate, then the general law will come back into operation. And in our case, my lord, the special law continues to operate. The general law cannot operate as long as the special law is in existence. And my lord, the non-abstenter clause cannot give a cumulative benefit or additional benefit. It only gives an alternative benefit.
Okay.
Yes, so that is my submission with respect to that non-abstenter clause, my lord. And like I said, my lord, that non-abstenter is quite different from in addition to clause. In addition to clause is also found in the, my lord, in the Consumer Protection Act. So that is different. Now, finally, my lord, they had also mentioned about certain benefits, and they had relied on Jatinder Singh's case, my lord. This is a 2010 Supreme Court judgment. My lord, I have the 2010 Supreme Court judgment, lordship. Jagdish, they had referred, Jatindra Kumar Singh, my lord, they had referred, the senior advocate, my lord, and he had mentioned that even if you take benefit under the reservation category, you can still be considered for an unreserved post. So he had relied on this Jatinder Singh's case, my lord, and there is a judgment of the Supreme Court, my lord, that runs exactly counter to this Jatinder Singh's case, my lord, and we have that judgment. One minute.
How much longer will you take?
My lord, just very few minutes, my lord. Just
wind up, please.
Yes, my lord.
Then
This one. Yes, my lord, this judgment of the Supreme Court, my lord, this was reported in 2017-12 SCC 685. Sorry. This was reported in 2017-12 SCC 680.
Para?
My lord, this is a very short judgment, my lord. If I may be allowed to read the judgment, my lord, it's only very few paragraphs.
Please remove these books, okay? You can send it to the chamber. Take it also.
Now this clause, this case also, my lord, has the same clause like ours, like our section 5, my lord. Paragraph number 2, my lord. The appellant applied for the post of laboratory.
Yes, read.
Yes. My lord, the appellant applied for the post of laboratory assistant grade 2 in Export Inspection Council of India, functioning under the Ministry of Commerce and Industry, Government of India. The appellant belongs to Dheer Vara community, which is one of the other backward class. Since the appellant was aged 25 years, she got age relaxation. My lord, at paragraph number 2.
Yes, read.
Yes, she got age relaxation as was granted to OBC category candidates. The appellant was one of the 11 candidates from OBC who was called for interview. The appellant secured 82 marks in the list of candidates from OBC category. One Miss Serena Joseph OBC, who secured 93 marks, was selected and appointed. Insofar as the general category is concerned, no candidate has secured the minimum cut-off marks, that is 70 marks. Stating that the appellant has to be accommodated in the general category, she filed a writ petition before the High Court, which the learned single judge dismissed by the judgment dated 16/1/2015. Being aggrieved, the appellant challenged the same in writ appeal number 8257 of 9/2015, which came to be dismissed, which is impugned in this appeal. The appellant, who has applied under OBC category by availing age relaxation, also attending the interview under the OBC category, cannot claim right to be appointed under the general category. Paragraph 4, my lord. Paragraph 5. The recruitment by the Export Inspection Council of India, which is functioning under the Ministry of Commerce, Government of India, is governed by the Export Inspection Agency Recruitment Rules 1980. As per Rule 9, the rules regarding relaxation of age limits and other concessions are to be governed by the rules and also the orders issued by the central government from time to time. In this regard, Rule 9 reads as under, saving. Nothing in these rules affect reservations, relaxation of age, limit and other concessions required to be provided for the scheduled caste, scheduled tribes and other special categories of persons in accordance with the orders issued by the central government from time to time in this regard. My lord, this is almost verbatim reproduction of our case. Now, my lord, because of this provision, my lord, issued by the central government from time to time in this regard, from paragraph number 6, they relied on the central government notification. The Department of Personnel and Training had issued proceedings OM number so-and-so, dated 22/5/1989, and OM number so-and-so, laying down stipulations to be followed by the various ministries, departments for recruitment to various posts under the central government and the reservation of SC, ST, OBC candidates. The proceedings reads as under. My lord, page number 682. As part of the measure to increase the representation of SC, ST in the services under the central government, the government have received the procedure for implementation of the policy of reservation while filling up reserve share of vacancies for scheduled castes and scheduled tribes by direct recruitment. The practice presently being followed is to adjust SC, ST candidates selected for direct recruitment without relaxation of standards against the reserve share of vacancies. The position of such SC and ST candidates in the final select list, however, has determined by their relative merit as assigned to them in the selection process when sufficient numbers of suitable scheduled caste and scheduled tribe candidates were not available to fill up all the reserve share of vacancies. SC, ST candidates were selected by relaxed standards. It has now been decided that in case of direct recruitment to vacancies in posts under the central government, the SC and ST candidates who are selected on their own merit without relaxed standards along with candidates belonging to other communities will not be adjusted against the reserve share of vacancies. The reserve vacancies will be filled up by separately from amongst the eligible SC and ST candidates, which will thus comprise SC and ST candidates who were lower in merit than the last candidate on the merit list, but otherwise found suitable for appointment even by relaxed standards if necessary. All ministries, departments will immediately review the various recruitment rules, examination rules to ensure that if any provision is contrary to the decision contained in previous paragraph exists in such rules, they are immediately suitably modified or deleted. These instructions shall take immediate effect in respect of direct recruitment made hereunder. These will also apply to selections where, though the recruitment process has started, the results have not yet been announced unless in the examination recruitment rules or in the advertisement notified earlier there is a specific provision to the contrary and the manner in which the SC, ST vacancies could be filled has been indicated. Clarification: the instructions contained in the above OM apply in all types of direct recruitment, whether by written test alone or written test followed by interviews alone. The above OM and OM number so-and-so dated provides that in case of direct recruitment, the SC, ST, OBC candidates who are selected on their own merit will not be adjusted against reserve vacancies. In this connection, it is clarified that only such SC, ST, OBC candidates who are selected on the same standards as applied to general candidates shall not be adjusted against reserve vacancies. In other words, when a relaxed standard is applied to selecting SC, ST, OBC candidates, for example, in the age limit, experience qualification permitted under the chances in written examination, extended zone of consideration larger than what is provided for general category candidates, etc., the SC, ST, OBC candidates are to be counted against reserve vacancies. Such candidates would be deemed as unavailable for consideration against unreserved vacancies. On a combined reading of Rule 9 of the Export Inspection Agency Rules 1980, which is just like Section 5 below, and also the proceedings dated 1/7/1998, which would also apply to us, we find that there is an express bar for the candidates belonging to SC, ST, OBC who have availed relaxation for being considered for general category candidates. Now, my lord, my lord, this line is important. Who have availed relaxation, my lord. So you might be an SC, ST, my lord, but you might have never availed relaxation. Then in that case, it's different. But the petitioner number, respondent number 5, availed relaxation. Yes. And below, my lord, this Supreme Court discussed that case which was cited in the morning by the senior advocate, my lord, Jatindra Kumar Singh. Paragraph 9. The learned senior counsel appearing for the respondents has also drawn our attention to paras 67, 65 and 72 in Jitendra Kumar Singh to contend that the principle in Jitendra Kumar Singh is in the context of interpretation of the UP Act 1994 and the particular factual situation of the said case, paras 62 and 72 read as under. In any event, the entire issue in the present appeals need not be decided on the general principles of law laid down in various judgments as noticed above. In these matters, we are concerned with the interpretation of the 1994 Act, the instructions dated 25/3/1994, and the government of order dated 26/2/1999. The controversy herein centers around the limited issue as to whether an OBC who had applied exercising his option as a reserve category candidate, thus becoming eligible to be considered against a reserve vacancy, can also be considered against an unreserved vacancy if he/she secures more marks than the last candidate in the general category. Soon after the enforcement of the 1994 Act, the government issued instructions dated 25/3/1994 on the subject of reservation for scheduled castes, scheduled tribes, and other backward groups in the Uttar Pradesh public services. These instructions inter alia provide as under. If any person belonging to reserve category is selected on the basis of merits in open competition along with general category candidates, then he will not be adjusted towards reserve category. That is, he shall be deemed to have been adjusted against the unreserved vacancy. It shall be immaterial that he has availed any facility or relaxation, like relaxation in age limit available to reserve category. From the above, it becomes quite apparent that the relaxation in age limit is merely to enable the reserve category candidates to compete with the general category candidate, all other things being equal. The state has not treated the relaxation in age and fee as relaxation in the standard for selection based on the merit of the candidate in the selection test, that is main written test followed by interview. Therefore, such relaxation cannot deprive a reserve category candidate of the right to be considered as a general category candidate on the basis of merit in the competitive examination. Sub Rule 2 of Section 8 provides further provides that government orders in force on the commencement of the Act in respect of the concessions and relaxations, including relaxation in upper age limit, which are not inconsistent with the Act, continues to be applicable till they are modified or revoked. Having regard to the observations in para 65 and 72, in our view, the principle laid down in Jitendra Kumar Singh cannot be applied to the case in hand, as rightly pointed out by the High Court that the judgment in Jitendra Kumar was based on a statutory interpretation of the UP Act 1994 and government order dated 25/3/1994, which provides for entirely a different scheme. So, my lord, that Jitendra Kumar also is not applicable. And finally, my lord, the other point that was raised by the other side, my lord, was the non-joinder of parties.
Yes.
My lord, in this case, my lord, let me quickly read through, my lord, some few Supreme Court judgments, my lord. My lord, the first one is reported in 1962. 1962 SCC online, SC 130, my lord.
Yes.
So, my lord, I will.
Give me the page number.
I will, my lord. I will do that, my lord. This case talks of necessary parties and proper parties.
You need not read everything. You just give me the citation, the page numbers. I'll read myself.
Yes, my lord. Paragraph 12. Paragraph 12, my lord. It says to summarize.
This is on non-joiner of parties.
Non-joiner of parties. And they are basically saying, my lord, their submission, as I can remember, as I can understand, is we have not implemented Singhania University, the two universities, UGC and DGC, my lord. So they have stated that we have not implemented these four parties, my lord. And now, my lord, at paragraph number 12. To summarize, my lord, in a writ of certiorari, not only the tribunal or authority, that is, my lord, respondent numbers 1 to 4, whose order is sought to be quashed, but also parties in whose favor the said order is issued, which is respondent number 5, my lord, are necessary parties. But it is in the direction of the court to add or implement.
Discretion.
Sorry, my lord. It is in the discretion of the court to add or implement proper parties for completely settling all the questions that may be involved in the controversy, either suo motu or on the application of the parties to the writ or an application filed on the instance of such proper parties. Now, my lord, in this case, the court made a distinction between necessary parties and proper parties, my lord. And the court, my lord, basically says that a proper party does not have to be implemented unless it's insisted, and a necessary party has to be made parties. In our case, my lord, the respondent numbers 1 to 5 are basically the issuing authority who had issued the appointments orders, and the respondent number 5, my lord, is the person who was the benefit, who had received the benefit. And my lord, there's another Supreme Court judgment, my lord. I'll also take your lordship only to the relevant part, my lord. Paragraph 2. This was reported in 1992, Supplementary Volume 2, SCC 351. And my lord, the relevant part. The relevant part is, my lord, at paragraph number 104 and 105, at page number 399. My lord, it says like this.
Yes.
My lord, I'll read paragraph 104. On the contrary, we think we should approach the matter from this point of view, viz., to render an effective decision whether the presence of Chauhan is necessary. We will in this connection refer to so and so, it is held as under. So it cited this, and then finally paragraph 105, my lord, says, what was the first respondent seeking in the writ petition, my lord? What are we seeking in the writ petition? He was questioning the validity of the ordinance and the act whereby he had been deprived of his further continuation. What is the relief could he have asked for against Chauhan? None. So, my lord, the Supreme Court said, because you have not asked for any relief against, no relief is asked against this person, he's not a necessary party. Finally, my lord, there is one more judgment. This was reported in 2012, volume 8. Page number 706. I'll read only paragraph number 27.
This is also non-gender.
Non-gender, my lord, but this makes it very clear, my lord. Paragraph number 27 only, my lord. Apart from the above aspect, in the case on hand, the application for rejection of the plaint of the appellant, first defendant, seeks no relief against the respondent herein. My lord, we seek no relief against them, my lord. Second defendant, it is settled legal position that a party against whom no relief is claimed in the application is not a necessary party at all. My lord, we have claimed no relief against them. We are only using their documents which they have published in their websites. And these are public documents which requires no further proof. And my lord, finally, there is one other judgment of the Supreme Court. This is of 2015, my lord. Poonam versus State of UP. I will not read this, my lord. I will only tell your lordship of the relevant paragraphs. And I'll read only one line, my lord.
Give me the citation.
My lord, this is from Kanun, India. So, my lord, I have provided.
Kanun, India.
My lord, I could find only from Kanun. My lord, paragraph 14 is relevant.
Para 14.
Paragraph 14. Then, my lord, paragraph 14, 15. And then, my lord, paragraph number 16. 14, 15, 16, my lord. The entire thing is only about necessary parties and proper parties, my lord. But 16 is important. But, my lord, I'll not read entire 16 also, my lord. I'll read the last part of 16, where a judgment of a Supreme Court was cited, quoted. My lord, this is at page number 7. Page number 6 and 7.
Yes.
Yes, my lord, page number 7, the principle. My lord has seen the principle? The principle that has been culled out in the said case is that a tribunal or authority would only become a necessary party which is entitled in law to defend the order. Now 17, my lord. The term entitled to defend confers an inherent right to a person if he or she is affected or is likely to be affected by an order to be passed by any legal forum, for there would be violation of natural justice. Now, my lord, I ask myself, my lord, this question. What kind of, my lord, their right would be affected, my lord? This is the question I keep asking myself, my lord. And my humble understanding is, my lord, their right would never be affected, even if they are not implemented as parties.
That's it.
And this case also, my lord, talks about the applicability of CPC, my lord, in the writ petitions. It says that CPC applications, my lord, if your lordship will come, if your lordship will see at page number 9. My lord, paragraph number 21, your lordship has seen. It's quoting another Supreme Court judgment, which is at paragraph number 21, at page number 9. We have referred to the aforesaid passages as they state the basic principles behind the doctrine of natural justice. That is, no order should be passed behind the back of a person who is to be adversely affected by the order. The principle behind Proviso to Order 1, Rule 9, that the Code of Civil Procedure enjoins it, and the said principle is also applicable to the writs. Now, my lord, my humble understanding, my lord, is that as per the CPC, my lord, Order 1, Rule 13, in fact, my lord, I have a judgment of the Madras High Court. I'll read only 3 paragraphs, my lord, because that judgment has made it very clear. Because, my lord, what we have seen is this issue of non-joinder, my lord, was never raised by the respondent number 5 in their entire pleadings. Only for the first time during this final hearing, my lord, they have mentioned about non-joinder of necessary parties, my lord. The entire pleadings, it has been absent.
What is there in the
NIT
Madras?
also has not raised, my lord. This judgment, my lord, at page number 60. My lord, at paragraph, I'll read from 61, my lord. Paragraph number 14, 15, and 16, my lord. It has been held in state of Orissa versus Shyam Sundar Panigrahi, AIR so-and-so, where a necessary party is not impleaded, the objection, even if not taken in the trial court, cannot be said to be waived and that it could be raised even at the stage of revision. However, the Bombay High Court has taken a different view of YG Chavan versus Parvati Bhai and has observed that an objection on the ground of non-joinder would be raised only in cases in which it would be fatal to the maintainability of the suit. If a party who has not been joined in a suit is merely a proper party, as distinguished from a necessary party, it would be futile to raise any objection of the nature contemplated by Order 1, Rule 13 of the Code of Civil Procedure. Such an objection would never be raised because in view of the provisions of Order 1, Rule 9, it would not be fatal and the court would always proceed with the suit in regard to the rights and interests of the parties actually before it. The reasoning in the Bombay High Court in the above-mentioned case appears to be more logical, and I respectfully follow the same. In the instant case, the non-joinder of Amirtha Wali Achi has not been raised in the written statement, and it must be held that defense has been waived by the contesting respondents. So, my lord, in our case also it was not raised, and non-joinder of proper parties, my lord, is protected by Order 1, Rule 9. Order 1, Rule 9 specifically says, my lord, that no suit should be defeated only because of non-joinder of parties and except for necessary parties. Rule 13 specifically says it would be deemed to be waived if it is not pleaded, and they have not pleaded, my lord. And if I may read, my lord, was Order 1, Rule 13 of the CPC, my lord. I'll read. It says like this, my lord. All objections on the ground of non-joinder of misjoinder of parties shall be taken at the earliest possible opportunity, and in all cases where issues are settled or are before such settlement, unless the ground of objection has subsequently arisen, and any such objection not so taken shall be deemed to have been waived. My lord, this is Order 1, Rule 13 of CPC. In our case, my lord, after we filed the additional affidavit, they took 1 year to reply to these 2 additional affidavits, my lord. And in spite of those 1 year, my lord, they did not raise this issue.
It is abstracted in the judgment itself,
Yes.
paragraph 30. Okay,
Yes, my lord.
that's all.
That's all.
Your Lordship, with your Lordship's kind permission, regarding one missing page that my learned friend had referred to, after page 40 of my affidavit, my Lord, there is one, with your Lordship kind permission, if I may supply Lordship with this page. After 40, my Lord, there has to be one last page on which the name of the respondent number 5 also is reflected, my Lord. After 40 of my affidavit, Lordship. That also, the same document is at page 81 of the affidavit, counter affidavit filed by the private respondent, my Lord.
My lord, this was for the first time I'm seeing this, my lord. Anyway, my lord, even in spite of this, my lord, again, the reason is not mentioned here also. So my submission, my lord, will remain the same in spite of this, my lord.
My lord, while referring to the affidavit in opposition of respondents 1 to 4, if I am allowed to submit only one point. That affidavit in opposition of respondents 1 to 4, my lord, page 17. This is the representation submitted by me. If I am allowed to point out this, to reply only on this particular point, my lord.
Which?
Affidavit in opposition of respondents 1 to 4, page 17, 17, my lord. This is my representation.
Now that we have seen.
Yes, and what I am trying to say is that, my lord, at the second para, I have stated that I had also submitted my scheduled tribe certificate for claiming my age relaxation.
Okay.
And at the second para, at the initial sentence, I have mentioned about this departmental candidate age relaxation 5 years. And at the end of this particular para, I have also mentioned about scheduled tribe age relaxation. That's all, my lord.
Okay.
Obliged.
Please write. Heard Mr. Joseph L. Rentley, learned counsel for the petitioner, Mr. P.J. Saikia, learned senior counsel, assisted by Mr. Bilal Ramena, for the respondent number 5, and Mr. C. Zoram Chana, learned. You are standing counsel?
Standing counsel, Lordship.
Standing counsel NIT for respondent numbers 1 to 4. Hearing concluded, judgment reserved.
Obliged, Your Lordship.
Item 3.
May it please Your Lordship? This pertains to the unwarranted issuance of the impugn letters dated 4/11/2024 and 9/11/2024, along with the impugn notification dated 4/11/2024 and 20/11/2024, my lord. The petitioner number 1 is the coach and the president of the Ramhlun Athletic FC, and the rest of the petitioners, 5 other petitioners, are the players engaged by the Ramhlun Athletic FC, my lord. Due to our, on account of our appearance at the last MPL season 11, we managed to secure the 6th spot in the last MPL, which automatically enabled us to participate in the next upcoming season 12 MPL, my lord. However, the respondents number 8 has issued the impugn letters I have just mentioned, along with the notification wherein we have been banned from taking part in any football activities or its related activities for a period of 3 years, not only within the state of Mizoram but throughout the entirety of India, my lord.
Okay, tell me one thing.
My lord.
The other day, respondent number 7 to 8 was supposed to file an affidavit. You have not filed.
Yes, my lord, we have filed.
I have not seen it.
My lord, it's a counter affidavit to IA for stay.
Oh, it's to the IA,
Yes,
not
my
not on the main writ petition.
Yes, my lord. My lord, the question of maintainability is still open, even though notice is already issued.
You file counter affidavit in the IA.
Yes, my lord.
I see.
That is for
I
the
was looking
stay.
at the main writ petition. That's why.
My lord, it's almost the same. It's almost the same case as item number 1.
So why is it listed today? For what purpose?
My lord, there is an urgency in the matter, my lord. I have just mentioned that we have secured the 6th position, the 6th spot in the last MPL 11, season 11, which enabled us automatically to participate in the next season 12. So due to the unwarranted issuance of the wrongful issuance of the impugn letters, we have been banned from taking part, and our spots have also been sold by the respondents without even proving our case, my lord.
What has been sold?
Our spot, the number 6 spot, has been sold
Has been sold.
off to some other clubs, my lord. Hence, we are left with no alternative, my lord. We have also filed our appeal, which the respondents have been delaying till date from last year, November. To 13 November, we have filed our first appeal petition. They have been silent. Had they not been silent, my lord, this whole writ petition would not have lied.
Okay, what have you challenged the writ petition?
I have challenged, in the main writ petition, I have challenged the impugn letters, my lord. The impugn letters dated 4/11/2024 and 9/11/2024, along with the impugn notification dated 4/11/2024, along with notification dated 20/11/2024, my lord.
Where are they in excess?
At page number... impugn letter dated 4/11/2024, my lord, is from page number 70. Impugn notification is at page number 69, my lord. Annexure number 8 of my writ petition.
69.
Yes, my lord.
69 is that list, isn't it?
Yes, my lord. This is the impugn notification.
Is this similar to the other one?
Yes, my lord.
Okay, same list.
Same as in the only not similarity in our case is that we
You are
are
players.
Oh yes.
Oh, you are a club.
We are also a club and have also secured the position of automatic, enabling us to automatically play in the
Okay, come to
season
page
12.
69.
Yes, my lord.
Where are you placed? Serial number?
Yes, in the official table, I am the number 2, Daniel Duoma. So in players, number 17, Flavius Lalwatkima, is the petitioner number 2.
Where? Serial number?
17 in the players section, my lord.
This petition number 2.
Yes, Flavius Lalwatkima is the 17
Yes.
and the second petitioner. Third petitioner is at 18, second 18 one, C. Vanal Shiata.
Petition number 3.
Yes, my lord, C. Vanal Shiata.
Yes.
And thereafter, on that same day, we were issued the disciplinary committee letter, my lord.
So 3 petitioners in all?
No, 6. So later on, they conducted another disciplinary hearing wherein the rest of the 3 petitioners were then penalized, my lord.
They are not a part of this list.
They are not a part of the list, my lord. Separately, the respondents have issued a separate notification, my lord. The list is at page number 82, annexure number 18.
Just a minute.
Yes, my lord.
There is P2. Yes, the remaining petitioners?
Is at page 82, annexure number 18.
82. Who are they? Name?
Serial number 2, Jonesler Chakima.
He is petition number 4.
He is petitioner number 4, yes, my lord.
Then?
And number 4 of serial number 4 is the petition number 6. And serial number 5 is the petitioner number 5.
6 in all.
Yes, my lord, 6 in all.
Then a separate order for them also?
Yes, my lord. Impugn letter for the respondent number 4, 5, and 6 starts from page number 79, annexure 15. The whole content from the impugn letter dated 4/11/2024 is similar as the impugn letter dated 9/11/2024, my lord.
So in this case, what has happened to the appeal? Some similar appeals have been filed?
Yes, my lord. Intention to appeal for the petition number 1 to 3 was filed on 6/11/2024. And for the petitioner number 4, 5, and 6, the intention to appeal was filed on 12/11/2024. Thereafter, appeal for the petition number 1 to 3 was filed on 13/11/2024, which is at annexure number 101, annexure 21, page number 101, annexure 21. So appeal for the petition number 4 to 5, 4, 5, and 6 was again filed on 18/11/2024, page 128, annexion number 22.
Okay, do you have a list of dates for all that?
Yes, my
They're
lord.
all different dates.
Yeah, because, my lord, they were penalized on different orders, my lord. 1, 2, 3 were penalized by impugn letter 4/11/2024, and the petitioner number 4, 5, and 6 were penalized by impugn letter dated 9/11/2024, my lord.
Okay, you tell me, intent to file appeal or something, what do you call that?
Intention to appeal,
Intention to appeal.
yes.
When was it filed by them?
Yes, for the petitioner number 1 to 3, it was filed on 7/11/2024.
And petitioner number 4 onwards?
And 4, 5, and 6, an intention was filed on 12/11/2024.
12/11,
2024.
okay. And
And
that's it.
appeal petition was, yes.
Appeal petition filed by?
Petition number 1 to 3 on 13/11/2024,
13?
11/2024. And appeal petition for petitioners number 4, 5, and 6 was filed on 18/11/2024.
Yes.
Yes. Thereafter, we submitted a request to the respondent number 7 to provide us the grounds of the decision so that we may prepare ourselves for the appeal hearing. However, till date, they have not replied to the said email. And thereafter, we also filed a complaint to the AIFF for their intervention. Again, we also submitted a complaint to the AFC and the FIFA as well, but no interventions has been taken up by the said authorities. In the meantime, my lord, the respondents have made an advertisement which is at page 163, annexure 26 of my writ petition.
Page?
Page 163. The true English translation is at 164.
What is this?
This is the application to play in MPL 12. What happens was that, my lord, in the last MPL season 11, 6 slots were reserved for players who manage to get a hold of that spot. They can automatically play in the next season without having to play the playoffs, which most of the other clubs will have to do. Now I have also obtained the 6th slot, which gave me a right to participate automatically in the next season, my lord.
How is that? That's depending on your score. Points.
It seems so, my lord.
How do you earn that spot?
Because there was some in the football game. There is some league. Yes, okay. So it's played by leagues. So on the points obtained by the clubs, there are 6 slots which can be captured by clubs of different clubs within the state of Mizoram to enable them to play in the next season.
If you don't have that, then what is to be done?
I will have to play the playoffs like the rest of the clubs.
You have to play?
Playoffs. I will have to obtain some. It's quite technical, so I am not very. Yeah, it's a very technical football term, which I am sure the respondent number 7 will be at more liberty to.
No, you have this
explain.
World Cup football, isn't it?
Yes, my lord.
I mean, everybody cannot just play like that. You have to qualify for that.
Yes, yes. So I have qualified to play in the next season automatically, my lord.
So those who get the
top 6 spot.
In the World Cup also, I think the winner gets to play without going for the qualifying round.
Yes, my lord.
Others will have to qualify.
Yes, my lord.
But in this kind of...
In this MPL, Mizoram Premier League, there are 6 slots available to be captured by clubs, my lord. So amongst the 6 clubs, I was one of them
Okay.
So, which automatically give me the right to participate in the next season without having to play the qualifying matches.
Okay.
So what happened is that since I was penalized, my slot has been left open, which literally means that I was relegated from the club, from the top six. That gives the respondents time to sell my spot, my lord, my rightful spot, without having proved my case.
See, this morning we had dealt with one matter.
Yes, my lord.
The appeal was pending, so appeal should be decided.
My lord.
So why should we take, I mean, similar orders can be passed in this also.
My lord, the thing is that the MPL season 12 is starting day after tomorrow. Now we have filed this appeal last year on November, my lord. We have waited till date. Now the respondents have been silent. If they had not been silent and decided our case,
No, for that you should have pressed the court also.
yes, we have pressed, my lord. Hence, we have filed the...
We should have mentioned and said that this is what is happening. You should have impressed upon the court.
Yes, my lord. That is why I have requested your lordship yesterday that this is a matter of urgency to have the matter listed again
That
today.
is there, no doubt. See, last minute, we cannot just, say that let them play subject to outcome of the writ petition. We cannot say like that. This is not that kind of case, you see.
My lord, I have also submitted the urgency in the second last court date as well. Since they have not filed their objection, my lord, time was granted to the respondents to file the affidavit, which they only filed yesterday, my lord.
What is the case number?
70 of, IA is 96 of
There's
22.
another case, 58, which is disposed of.
My lord,
58. That was way back in June.
yes, my lord.
That was not your case.
No, that was not my case. I have filed my case on 24/6/2025, my lord.
After the disposal of that writ petition.
Yes, my lord. Since at the time of filing my writ petition along with the IA, my lord,
So that is why you see, you should have come before the court earlier.
my lord, I have, because there was alternate remedy, my lord, the appeal was...
Maybe,
Yes,
if nothing is moving, then you have no other option to come but to come to the court.
yes, my lord, hence
Isn't
we
it?
have come, yes.
How long should you wait? If you could wait for 6 months, why not wait for 1 more year then? This is the thing you see. You should come at the earliest. Like, representations are filed. People file 10, 20 representations. They come after 10 years. That's not the thing, you see.
My lord, the respondents...
You file one precise representation, make a reminder, nothing happens, then you come to the court.
My lord, if I may have your lordship's attention to page 182 of my my writ petition, annexure 29. Yes, the respondents have issued me a notification stating that there is a mandatory in-person appeal hearing, which is a notification issued to me by the respondents, stating that the hearing will be conducted on 15 February 2025.
Where?
At page 182, my lord.
Then what happened on that day?
On that day, my lord, it was cancelled by the respondents.
Simply cancelled.
Yes, through...
No further date.
No, telephonic conversation was made to me to inform my other players as well, stating that they will require some time and that they will inform me the date on which the hearing will be conducted, my lord. We waited and waited, then the notification for the next MPL was then issued, my lord, while we wait for the appeal hearing. I have annexed the first notification issued by the respondents for the starting of the MPL season 12, which is at 118 page, number 118.
See, this 182 has been given to everyone,
Yes, my lord.
15 February.
Yes, my lord. So I was called up on 14th of February, stating that the hearing which will be conducted the next day has been cancelled. and that we will be given further a date on a further time.
Then what is 118?
118, thereafter we waited for the intervention of the respondent number 7 and 8, my lord. So while we await for their response, page number 118, annexion number 35, notification was issued by them stating that MPL season 12 will be starting on July 17, 2025, my lord.
No, that's not 118. Which page?
188, my lord, I am sorry, 188.
188.
Yes, my lord, annexure 35.
What is this?
This is a notification issued by the respondent stating that the MPL season 12 will start from 17 July 2025.
When was it issued?
Sometime in the month of June. I cannot recall, my lord. So that was issued, hence we have to file our writ petition immediately. In the meantime, my lord, we have also submitted a complaint to the FIFA on 9/5/2025, my lord.
This is annexure 35.
Yes, my lord, the notification is annexure 35.
Now, where is the statement to support that?
This has been extracted from their page, my lord, from the
No,
respondent's.
you have given two annexure 34s. One is at page 35, one is at page 43.
43.
Oh, this is typographical mistake. Instead of 35, you have written 34. Page 43 of the writ petition.
Yes.
But see, you should have at least mentioned, when did you come to know about this MPL season 12? Your statement is at paragraph 26. You have come to know from via social media. Isn't it?
Yes, my lord. The social media post was made on May 5th.
That means, of course, your writ petitions filed on 24th June.
Yes, my lord.
Much prior to this, you must have known. So,
Yes, my lord.
you took your own time to come to the court.
Actually, my lord, before coming to this court, there was the highest authority, FIFA, which was still available. So we had to file the complaints to them, my lord. So we filed the complaint on 9/5/2025, my lord, which is at page 175, annexure 28.
One
175, annexure 28.
What is the response?
No response. That is why, my lord, we have availed all alternative remedy available. Hence, we have no other alternative.
When was this sent?
This was sent on 9/5/2025, my lord.
Where do we get the date?
The date is at page number 181,
9/5/25.
just after the issuance of the notification, my lord. So we have exhausted all remedy available to us, since the respondents have not complied in disposing our appeal, my lord.
So what is your prayer today?
My prayer is for setting aside the impugn letter dated 4/11/2024 along with the impugn letter dated 9/11/2024 and the impugn notifications dated 4/11/2024 and 9/11/2024, my lord.
No, for that, we'll have to hear the other side also.
Yes, my lord.
Pleadings will have to be exchanged.
As of now, my lord, we are praying in IA, we are praying for staying of the MPL season 12, my lord, until disposal of the writ petition, my lord.
Stay of the season, MPL season 12.
Yes, my lord.
Who organizes the MPL?
Mizoram, the respondents, my lord. Respondent
7 and
number
8.
7.
7.
7, yes, my lord.
Now, insofar as the writ petition is concerned, notice was issued
My lord.
and everyone has appeared.
No, my lord, respondent number 6, my lord. Notice has not been directed by this court or by the manner in which the notice has to be served, my lord. So
By which order?
it has not been made, my lord, order to serve notice to the respondent number 6. It has to be either by way of...
Why not? It says here, at order dated 26/6. It says Ms. Vanne, CMA accepts notice on behalf of respondent numbers 1, 2, 3, and 5. As regards 4, 6, 7, and 8, registered post. So, how many respondents are there?
8 in total, my lord.
8 in total. So everyone is taken care of. I think 7 and 8 are appearing and 1 to 5 are appearing, except for 6. No, what is this? Who's number 4? Who's number 4? Oh, President. State Sports Council. This also, I think, notice has to go. Notice had gone. So 1, 2, 3, and 5. Correctly issued. And you have taken steps also. 4, 6, 7, 8.
Yes, my lord.
You're not aware
I
that you have taken steps?
was just confused, my lord, because I have written...
So that's what it is. Now, pursuant to that, I think 7 and 8 has appeared. Then, of course, state is there. Sports Council is not appearing. Sports Council, no one, isn't it? And what is this additional affidavit?
Yes, my lord.
Why additional affidavit?
Because there was subsequent developments after the filing of the writ petition, my lord.
What was that?
That the appeal fee was requested by the respondents, my lord.
Okay, then?
And then the respondents themselves has also postponed the starting of the MPL from 17 July 2025 to 21st August 2025, my lord.
So they have requested for the appeal fee.
Yes, my lord.
60,000 per person,
Yes, my lord.
per individual.
Per individual.
Okay, and what has, you have paid the fees?
No, my lord, that we are having financial constraint because we have been banned from taking any part in any activities, be it football or futsal, since November last year. So we our only mode of earnings has been blocked by the respondents. We are not saying that we will not be paying, but we are just requesting the respondents to lower the appeal fee a bit.
Lower the appeal fee?
Yes, my lord, because the fact is that the appeal fee to be paid as per 120 of the disciplinary court is to the appeal committee. However, this AIFF appeal committee is the national level. The appeal to be filed is before the MFA Executive Committee, which is just a state level. Moreover, they are not the appeal body as well. They still have to constitute the appeal committee to which we still have to file, which is also a state level. So just asking us 60,000, which has to be paid on national level, where we are already constrained with constrained on financial problems, as well as are been banned from taking part in any other activities, have a bit of a problem, my lord. So we are in a state of pickles, so we would like your lordship.
Okay. You have written on behalf of your client.
Yes, my lord. I have contacted with the
Can the
honorary
fee be lowered at a lower rate?
Yes, my lord.
You are ready to pay the fees, but at a lower rate because of your financial constraint.
Yes, my lord.
Okay. So that's the writ petition. Now, what happened to the earlier writ petition? Ms. Naisaki is there. This WPC 58,
Yes,
which
my
was
lord.
disposed of on
26/6.
19/6/25.
Yes,
Has
my
the
lord.
appeal been disposed of?
Yes, appeal is already disposed with the direction that their appeal be disposed within, preferably within 2 weeks. And then we have intimated those petitioners in this writ petition number 58 to pay the appeal fees so that we can proceed with the appeal proceedings. As
Appeal is not yet disposed.
it's not disposed because they have not paid the appeal fee in this as well. We have sent intimation as well to the petitioners in this. They have not paid the appeal fee. That is the mandate of Article 120 of the AIFF Code, my lord. Appeal cannot be admitted if an appeal fee is not paid. That, my lord, that is the only point of contention here, that we are ready and willing to dispose. Even though they are late, then there could be some condonation.
Okay, so that is the thing. Now, in the IA, you have prayed for stay
Yes, my lord.
of the MPL.
My lord, in the IA, they have prayed for stay. However, the appeal, the writ petition is not filed as per the club. Not in the name of the club. They were individuals. 6 individuals, 6 petitioners, my lord. If they had not put themselves into this corruption case, if they have not involved in a match fixing case, then, my lord, they would not be relegated. However, there are malpractices which is done by the petitioner. That is why the disciplinary proceedings and orders are being served upon them.
My lord, if I am allowed to make a submission.
See, in the IA, this IA is for stay of the game, isn't it?
Yes, my lord.
You had prayed that you may be allowed to file additional affidavit.
My lord,
You have not filed that.
I have filed, my lord.
Where? In the IA or in the main?
Both. It is with both, my lord. WPC 70 of 2025 with IA, my lord.
No, you have filed the additional affidavit both in the WPC as well as in the IA.
In the IA, my lord.
In the IA, there is no such kind of additional affidavit. Only that objection is filed by the respondent number 7 and 8. Ms. Naisaki has filed the objection, affidavit in opposition. That's all. But you had prayed for additional affidavit. That is not there. Did you file it or you did not file?
I have filed it, my lord.
When?
But, it was filed on 8/8/2025, my
Why
lord.
did you want to file that additional affidavit?
Because of the subsequent developments, my lord.
So that must be the one which you filed in the writ petition.
Yes, my lord.
But the order is given in the IA. It says, "Heard Ms. Valentina, learned counsel for the applicant, who prayed that she may be allowed to file additional affidavit to the affidavit filed in the IA."
My lord, I apologize, I have made a wrong nomenclature.
So this is the thing. Because of the appeal, we cannot say that you participate in the thing, nor can we say that the impugn orders are set aside. And it will be another thing to say that the MPL should stop. Now, let us see if we can convince the court.
Okay. So, my
Yes.
lord, yes, I am the coach at the Ramlun Athletic FC, and the petition number 2 to 6 are the players engaged by the Ramlun Athletic FC. Investigation was made by the...
Just a minute.
Yes, my lord.
Applicant number 1 is the coach.
Yes, my lord. Coach and the president of the Ramlun Athletic FC.
Coach and president also,
Yes, my lord.
Ramlun FC.
Yes,
And
my
the
lord.
others are the players of.
So what happened was that there was some seven suspecting the instant petitioners with the petitions along with other clubs members with regards to match fixing and match manipulations, which is a form of corruption, have invoked wrong provisions of law. The made against us is regarding the match fixing and match manipulation code of ethics of the AIFF, my lord. So under the code of ethics deals with the corruption in the form of disciplinary does not deal with such state, my lord. The wrong provisions from inception.
Where is your appeal? Show me your appeal.
Yes, my appeal is at page number 101. Yes, my lord.
2024. Other similar case was of the appeal in accordance with this to not applicable to you. So we'll dispose of the appeal.
My lord, even there is a reimbursement provisions.
Maybe. The appeal in accordance with that rules.
Yes, my lord.
Heard Ms. Valentina Laldinpui, learned counsel for the
Your Lordship, in this matter, I may kindly be given
Send
another.
somebody to collect this file from behind.
My Lord, I may kindly be given another 1 week time to file rejoinder. Within 1 week, I'll be filing it.
As paid for by Mr. B. Ramenga, learned counsel for the petitioners. A week's time is granted. Further 1 week time is granted to file rejoinder affidavit.
Much obliged, ma'am.
Item 5.
My lord, I am for respondent number 6. I may be given 3 weeks' time for filing my affidavit. Lordship, the state respondents have already filed.
Okay, as paid for by Ms. Zairam Sangpui, learned CGC. Further 3 weeks time is granted for filing counter affidavit. Stop. Ms. Caroline K. Lumoipui, learned government advocate, appears for the state respondents and submits that affidavit has already been filed by the state. List this matter again after 3 weeks on a date to be fixed by the registry. Your good name?
Stephen Lalbuatsaya.
Mr. Stephen Lalbuatsaya, learned counsel, appears for the petitioners.
Item 6.
Lordship, I was requested by the legal aid counsel here in these matters.
Pleadings are complete, Lordship.
He had some personal difficulty to appear today, so he informed that the steps have been completed and requested the matter may be listed for hearing.
If we can have it next day, Tuesday.
Which
my lord.
item? Item 5?
6, Lordship.
Okay.
Next Tuesday, my lord.
When?
Next Tuesday, if possible.
Next Tuesday.
My lord, yes. For admission hearing, my lord.
What is the urgency?
I don't know, it's pending for quite some time, my lord. It's up to your lordship, my lord.
What is the matter regarding?
It's about service, my lord. They have been terminated, my lord. And they have now come before lordship challenging that same, my lord. After 17 years, my lord.
We list it after 2 weeks.
My lord.
Submitted by the parties that pleadings are complete and that the matter may be taken up for admission hearing. Stop in view of above, list the matter on the admission column after 2 weeks.
Oblige.
Item 7.
My lord, the affidavit has been filed by the respondent number 1 to 3.
Lordship, I am appearing for respondent number 4. However, I have not yet received any instructions till date.
You want some more time?
Yes, my lord.
My lord, the writ petition can be disposed of on the basis of the statement made by the respondent number 1 to 3.
What is your claim?
A payment of rental compensation which has been assessed by the respondent number 4, and for acquisition of initiating the acquisition proceedings as per the right to fair compensation Act 2013.
We'll give her one more chance.
My lord.
3 weeks is the last chance.
Yes, my lord.
Ms. Zarem Sangpui, you have filed? Okay, respondents, except respondent number 4, have filed their counter affidavit as paid for by Ms. Caroline K. Lung Oipui, learned government advocate, appearing for respondent number 4. 3 weeks' time is granted as a last chance. List again after 3 weeks.
Right, Your Lordship.
Item 8.
May I please, Lordship?
Yes.
Lordship, as per the last order dated 17/7/2025, Lordship, the learned CCC is supposed to file her land allotment, Lordship, by way of affidavit, Lordship. Till today, I have not received, Lordship.
My lord, I already filed on 4/8/2025. Then the copy of that affidavit should maybe served to the colleague of the petitioner counsel, my lord. We'll check it.
Who is the colleague?
Ma'am, is this John? My lord, I haven't received any instruction, Lordship.
Ms. Zarem Sangpui, when did you file the affidavit?
On 4/8/2025. 4th of August.
They have filed already on 4/8.
Lordship, I haven't received anything, Lordship.
My lord, we'll inquire the matter because we already furnished to the colleague of the petitioner counsel.
Who is that? Who has given the signature? Counsel for the petitioner. Who has received it?
My lord, my junior texted for this, then. My junior texted for this, then I cannot.
No, at least they should write the name, no? So one signature is there, that's all. We don't know whose signature is there.
We'll inquire, my lord.
My lord, if my colleague can receive from her office, Lordship, tomorrow.
Who's your colleague here? Who's your colleague?
John is there, Lordship.
Who?
John.
John?
Yes, Lordship.
There are so many John. Which John?
John Silo,
John Silo.
Lordship.
Who is John Silo?
Lordship, his name is not mentioned in the course list, Lordship. Oh, John Londo, Lordship, I'm sorry. John Londo. John Londo.
John Unit Londo.
Lordship. He is the junior of the Lalram Ruata Silo, Lordship.
You ask him also?
Lordship.
Because somebody has given a signature here, receipt.
Lordship, I know they were, Lordship. My lord, and they are also supposed to file their affidavit, Lordship.
They have to file a what?
Counter affidavit also, Lordship.
That is what we are talking about, counter affidavit. What do you think we were talking about?
Lordship, the land allotment order, Lordship. As you
Land
have
allotment?
directed. Lordship.
Land allotment order, in terms of which order?
Lordship, first order, Lordship, 29/4/2025.
Yes, Ms. Zainam Sangpui, what about this?
My Lord, thereafter we are permitted to file by way of affidavit. Accordingly, we already filed affidavit.
No, if allotment was given, a copy of allotment order be produced.
My Lord, next court date, my Lord, in the next court date. I
Have
was-
you incorporated,
Yes, my Lord,
incorporated that in your affidavit?
Yes, my Lord.
Where? Page?
At page 21.
21. It is here. You serve one more extra copy.
Yes, my Lord.
Whom to serve here? You ask somebody to contact Ms. Zainam Sangpui,
Lordship, yes.
then she will give an extra copy.
Lordship.
Okay.
And Your
Ms. Zainam
Lordship, I'm
okay.
representing the respondent number 4 and 5, and I'm seeking another 3 weeks' time
3 weeks
to file
time.
affidavit.
4 and 5.
4 and 5.
Okay. Mr. B. Chakma, Learned Counsel, appears through RVC and submits that he has not received the land allotment order in favor of the BSF as was directed, white order dated 29/4/2025. Stop. Ms. Zainam Sangpui, Learned CGC, appearing for respondent numbers 1 to 3, submits that the allotment order has been incorporated in the counter affidavit which she has filed on 4/8/2025. Stop. Mr. B. Chakma, Learned Counsel, submits that he has not received a copy of the counter affidavit. To stop, it is seen that somebody has acknowledged receipt of the counter affidavit on behalf of the petitioner, but no name has been given except for the signature, which is dated 4/8/2025. To stop, be that as it may, Learned CGC shall furnish an extra copy of the counter affidavit to Mr. B. Chakma.
Your Lordship, if I may, I'm representing only the respondent number 4, GC.
You want time also for 4?
And for respondent number 5, that is Chakma Autonomous District, I believe that no one represent the respondent number 5 till date.
Yes, what about CADC? Notice is complete or not? CADC?
My Lord, earlier, yes, Lordship, may I please, Lordship?
Yes.
Earlier, Lordship, the 4 and 5, she was representing, but I'm also have a doubt, Lordship, the CADC, they have not standing counsel, Lordship.
So you take steps? Have you taken steps?
Earlier, I have provided one copy, Lordship, to the CADC for the interest of justice, Lordship. Despite this court have not ordered, Lordship, to submit the extra copy, Lordship.
Ms. Vanesiami, Learned Government Advocate, appears for respondent number 4 and submits that she may be given further, how much time?
3 weeks' time.
3 weeks' time to obtain instructions and to file counter affidavit. Prayers allowed. Next para, it is seen that although the learned government advocate was said to have accepted notice on behalf of respondent number 5, but today she submits that since respondent number 5 is the Chakma Autonomous District Council, she will not be in a position to represent them. Stop under the circumstance. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD due within.
Lordship, can it be Dusty, Lordship, if you permit, Lordship? Through Dusty, Lordship.
Within how much time?
Within 1 week, Lordship.
1 week?
Within 1 week, Lordship.
Okay, change that thing. Under the circumstance, under the circumstance, the petitioner is allowed to serve notice to respondent number 5 by way of Dusty within 10 days from today through the registry of this court, and thereafter file an affidavit as proof of service. List the matter again after 3 weeks.
My Lord, if I may, this case is included in the list of mediation. Then we already give a consent from respondent number 1 to 3, my Lord.
So what to do?
Then I don't know whether the petitioner or the state.
Lordship, I have not received any instruction, Lordship.
No, there is no such order here, there is no such column here for mediation. You have given only consent, but there has to be an order, isn't it? Was it listed for mediation earlier?
Not listed, because we are asking for the consent for this.
Actually, my lord, all the list which was put it for the mediation, they are not listed out. But there is one notification that if they want for mediation, they have to submit themselves and present that they have to fill up the form and mentioning that they want to go for mediation. But I believe that the petitioner did not aware of that, and I believe that they did not submit that form.
Okay, anyway, let it come after 3 weeks, we'll see. List again after 3 weeks. On a date to be fixed.
Item 9.
My lord, the respondents are yet to file the counter affidavit.
Yes, my lord, I have already received pairwise comments, and I will be filing my affidavit in position within 1 week.
What about in this case mediation? Is it possible?
I am not aware of this because this case is being handled by Miss Mary.
But there's an order passed by this court, you must have seen it. It says like this: when the matter is called today, learned counsels for the parties submit that they are waiting for instructions from their clients as whether they are agreeable to solve the issue involved in the aforesaid writ petition through mediator or not, and accordingly seek listing of the case after 1 week.
Lordship, if your lordship permits, I will seek instructions if they want to refer the case for mediation.
Yes, you have received instructions for, you have received pairwise comments.
Yes, my lord.
When can you get instructions then for mediation?
Within 1 week, my lord.
Okay. Ms. Caroline K. Lumopi, learned government advocate, seeks for further 1 week time to receive instructions as to whether the respondents are agreeable to send the matter for mediation. List again after a week.
Obliged.
Okay. Counter affidavit you want to file, you file, no problem.
Yes,
it doesn't
my lord.
prevent you. But get the instructions whether they want to send it for mediation or not.
Hearing item 1.
Yes, you ready for hearing?
Lordship, I believe the petitioner's counsel is not present today, and the matter was fixed for today. However, my lord, if the matter is going to be taken up tomorrow, I have some personal difficulties. I need to attend a medical checkup.
Okay, you inform your friends whichever matter is ready will take up, which is not ready will not take up.
Yes, my lord.
Okay. Call.